All right, well, welcome back from lunch. We've got a couple of topics to cover this afternoon. The next topic that we have is traffic and law enforcement issues, kind of a broad topic. We'll start with vehicular homicide and driving under the influence. Mr. Fuller, you provided us with the statutes. Why don't you just give us a brief overview of the existing statutes?
Sure thing, Mr. Chairman. So the statutes that I provided two statutes in this single document. The first is 62106, which is homicide by vehicle and aggravated homicide by vehicle. Subsection A provides the offense of homicide by vehicle if a person operates or drives a vehicle in a criminally negligent manner, and that conduct is the proximate cause of the death of another person. Subsection B provides the offense of aggravated homicide by vehicle. And a person is guilty of this offense if the person drives, and I'm going down the two paragraphs. So paragraph 1 is if the person, while driving or operating a vehicle in violation of a number of statutes, I think most relevant here would be 315233, which is the driving under the influence statute. A person causes the death of another person, and the violation is the proximate cause of the death. The other two statutes referenced there, the one in Title 10 concerns aircraft, the one in Title 41 concerns watercraft. Then paragraph 2 is a person is guilty of aggravated homicide by vehicle if the person operates or drives a vehicle in a reckless manner, and that conduct is the proximate cause of the death of another person. And then, Mr. Chairman, 315233, I would just point you to subsection E, which is on the 4th page of the document. That is the provision that talks about the penalties for driving under the influence. Those penalties vary depending on the offense and then the frequency of the offense in a particular time period. So if a person, for example, has 4 driving under the influence offenses within a 10-year period, that would be a felony offense. Mr. Chairman, I'm happy to go into further detail on that or answer any questions that the committee has.
Any questions about the statutes, committee? No? All right. Thank you, Mr. Fuller. Appreciate that overview. Let's move to Director Cusick. Welcome.
Good afternoon, committee. Thanks, Chairman Olson. We proposed an interim topic for study along with our friend Kate Gladden of Sheridan, who will speak after me, about whether or not the line is drawn in the right place for these statutes. We have more and more, we see distracted drivers on cell phones, and the data there, which I can share here in a bit, is very compelling. In many instances, it can be, well, not many, in most instances, it's more dangerous than if you're intoxicated, as long as that intoxication is 0.08 or below, which is the threshold for DUI. We also see vehicles that are much taller than they used to be, decreasing sight lines. We see vehicles that have a lot more horsepower than we used to. And we certainly see a lot more traffic, especially during parts of our busy tourist season. So the problem that we see with this, we see that it appears to us, at least, that perhaps prosecuting attorneys don't have a tool in the toolbox they might want to have. If we look at the definition of what reckless is, if we look at what distracted drivers are capable of, whether that be on their phones or otherwise, and the ways a person can be distracted as a driver is hither and yon these days. We were talking in the hallway about how if you're from Wyoming, you know when to slow down during wildlife migration season. You can tell if the animal is eating or getting ready to cross in those cases, but you're still vigilant, and yet we still have pedestrians and human beings being hit and killed in crosswalks. And our organization sees the crosswalk as a sacred place for pedestrians. It suggests to them that this is where you're supposed to be and it's where you're supposed to go. In the incident you heard about after me, a person was crossing with the green light in the middle of the day in downtown Sheridan and is no longer with us. We've had too many of those in Wyoming. We've had a couple here in Cheyenne. We had a person, a young school child going to school in Lander, hitting the crosswalk with their bicycle, and the driver said, well, the sun was in my eyes and I was turning right on red. That's distracted to me. I feel like there's room for opportunity for improvement there. So we've put forth some ways to strengthen that vehicular homicide statute as a packet here, or a 2-page document, and just are offering some suggestions for consideration. That might be in your, I believe that's in your packet. So yeah, the first one is that we think distracted driving, texting, or phone use that causes death should also be considered as an opportunity to apply the felony conviction. Some quick data on that. They've done some studies. Baseline crash risk, texting drivers are 6 to 8 times the baseline for risk. A DUI at 0.08 is 4 times as likely as a non-intoxicated person. So the rate with which you're going to cause some damage or cause a crash is higher if you're a person who regularly texts on your phone versus a 0.08 DUI. The phone use is intermittent, but happens for many drivers repeatedly. Phone use produces the equivalent of alcohol impairment or more and occurs vastly more often. But we also have, as I've mentioned, you can have the sun in your eyes. There's so many screens in the new cars, lots of things fighting for drivers' attention. What we're not trying to do is ramp up penalties for every situation, obviously, is a tragedy. We're looking for situations where, and in another area we're looking to make some changes, is having some sense of what the driver's past history was. We heard from LSO, I believe, 4 DUIs prior is reason. There's lots of other things that make a person an unsafe driver, in our opinion, and I think that should be available as well to prosecutors. If the person has 1 DUI, if the person has a history of bad decision-making behind the wheel, those kinds of things as well. We look at some justice for families, Kate's and many others. A misdemeanor conviction for the death of a family member is experienced as a second injustice. A person might not get any jail time and a life was taken. We're behind our neighboring states. I've provided that data. In most cases, we're behind them. In some cases, we're equal to them. I believe we're one of 4 states in the union that don't have that as an option unless the person's driving whatever currently reckless means or with a DUI involved. So those are some changes we're looking to make or suggesting that are made. And I close with this paragraph. Wyoming law already recognizes reckless or impaired driving that kills someone as a felony. This proposal asks the legislature to consider whether the line between criminal negligence and recklessness is drawn in the right place, and whether specific dangerous behaviors such as distracted driving, driving on a suspended license, prior dangerous driving violations should trigger the same level of accountability. And I'd stand for any questions.
Questions, committee? Before we get further into the testimony? All right. Appreciate your introduction of the issue. Thank you.
Thank you. Do you mind if I sit nearby to help?
You can absolutely stay there.
All right,
Yeah.
thanks.
So, Ms. Gladden?
Good afternoon, Chairman Olson and members of the committee. My name is Kate Gladden and I am a resident of Sheridan, Wyoming, and I want to start by saying thank you. When I testified before you in March, I asked you, alongside with Director Mike Cusick, to study this gap in vehicular homicide law, and you said yes. That decision means more to my family than I can truly express. I also want to thank Representative Connolly for sponsoring this topic and Senator Crago and Representative Kelly for their time in speaking with me about this issue. Alongside being a resident of Wyoming, I am the daughter of Julie Fitzsimons, who had travelled to Sheridan with my father from Sydney, Australia, to visit myself and my husband for a much anticipated family catch-up last year. But because of one driver downtown on May 28th last year, she never made it back home. You have my written submission already, and I won't repeat directly what's in it, but expand upon it. Because since I last addressed you, this case has moved forward, and what that process has revealed speaks directly to why this committee's work matters. As I shared in my last testimony, and you'll see in the Exhibit A of my written submission there, the driver who killed my mother was on probation for domestic battery and evading police at the time of the crash. He'd been given probation just 5 weeks prior. He also had a recent DUI conviction after crashing his vehicle and has 3 excessive speeding convictions up to 97 miles an hour and was required to carry SR22 insurance because Wyoming had already formally designated him a high-risk driver. To learn that someone with such a record of dangerous driving took my mother's life was distressing enough, let alone then hearing that her death was still charged as nothing more than a misdemeanor. Because of how the law is currently written, unless under the influence at the time of the crash or driving with such extreme recklessness that, in the words of our prosecutor, the driver would essentially have to be doing 100 miles an hour down Main Street with the police chasing them, the charge for vehicular homicide in Wyoming is automatically a misdemeanor. That means a maximum of just 12 months and/or a $2,000 fine, period. That's regardless of driving convictions or context surrounding the crash. The driver initially pleaded not guilty, then changed his plea as part of a deal. He now faces 365 days in jail with all but 60 days suspended. 60 days for taking my mother's life. That is the gap. And I'm asking this committee to give prosecutors one simple tool to close this gap: the discretion to escalate a vehicular homicide charge to a felony when documented aggravating factors are present, such as a prior DUI, SR22 status, prior convictions indicating a pattern of unsafe driving, or the death of a vulnerable road user in a marked crosswalk. Not a mandate, but a tool. Because driving is a patterned behavior. A driver's prior record on the road speaks directly to how that person operates a vehicle. In fact, the officer working our case told us he could clearly see this pattern of escalation in the driver's behavior. And research consistently shows that prior traffic convictions are among the strongest predictors of future crashes. We already accept this logic elsewhere in the law. Prior record is relevant to a charge in a DUI case. And what's interesting with the DUI, personally, as a daughter who's lived at the effect of this law, is the reason we don't want people driving under the influence is because they can harm someone or kill someone. Why does it matter if a driver does that sober? Like, I don't understand the impact for a family is the same. So, and then that's, I think, what's so frustrating or hard to wrap our heads around is that this entire record becomes invisible to our Wyoming law at the very moment it matters most. And that's when someone is killed on our roads. And also, I just want to share that the current misdemeanor classification doesn't just limit accountability for the driver and make our roads less safe. It shapes how victims' families are treated throughout this entire process. Sentencing was initially scheduled for April 10th, and my family spent months mentally and emotionally preparing for it. 4 days before sentencing, we were told that the pre-sentence investigation report ordered by the judge had not been completed. The corrections office was never informed of the sentencing date. As a family, we had to accept the date had to be moved, but finding that out 4 days before sentencing after months of preparation was devastating. And now sentencing falls on May 29th, the day after the 1-year anniversary of my mother's death. When I inquired how such an important date fell through the cracks, I discovered yet another gap. Circuit Court has no standard process for notifying PSI writers of sentencing dates because misdemeanor cases so rarely require one. A life was lost, and it was still being processed like a traffic violation. As you just heard, Director Mike Cusick share with you more of the research and proposed bill language. And I just wanted to be here today to share with you, as someone living this process, that the gap is real and the full weight of it falls on its families. I also just wanted to let you all know that I am personally doing whatever I can to prevent another family from standing in our shoes. So this month, alongside the city of Sheridan, we've launched a pedestrian awareness campaign throughout the entire town, and I can share some of these resources afterwards if you would like, because I really do believe in building safer roads and being proactive about that and really reminding drivers, eyes up, lives ahead. And I'm excited to see my town come together to walk with me for the first pedestrian awareness walk on May 30th. But I really believe that awareness alone is not enough, and accountability and deterrence matters. And that starts by giving prosecutors a law that recognizes the difference between a genuine tragic accident and the foreseeable result of years of dangerous choices on our roads. Because it all comes down to this. On May 28 last year, at approximately 12:11 p.m., my mother pressed the button on the corner of 5th and Main Street and waited for the walk signal. She crossed at the crosswalk. She did everything the law asked of her. And then a driver who has repeatedly broken the law on our road struck her moments later. She got a life sentence. He's getting 60 days. Her name is Julie Fitzsimons, and it's not too late to act in her honor and ensure that our law is ready the next time a driver like this gets behind the wheel and takes a life. Thank you. I welcome any questions.
Ms. Gladden, thank you for sharing your testimony with us. We are, there's never the words can't really, explain how we feel for you, but we definitely welcome your testimony. And it's, it takes a lot to testify in front of a legislative committee, especially when it's an emotional issue. So we really appreciate your testimony, and our deepest sympathy goes to you and your family. Committee, any questions for Ms. Gladden? Yes, Co-Chairman Washer, please.
Thank you, Mr. Chairman. Ms. Gladden, very much appreciate your testimony. I'm just curious about the plea bargain.
Mm-hmm.
Why so much of the potential jail time was negotiated away in that agreement. We often see here in this committee situations where in individual cases, the law as written isn't even used to its maximum. And then there's a request to increase the maximum, right? And we're going, we're not even using the maximum of the law we have. So I was wondering, did the prosecutor share with you any of the intricacies of how they came to a 60-day agreement?
Sure.
Ms. Gladden.
Chairman Olson to Representative Washut. A very interesting question, and one that, trust me, my family wrestled with a lot. So part of where all I can speak is on my personal decision, but it felt biased for that driver to be able to stand in front of a jury without them knowing his prior driving conviction and be able to stand there and act like it was his first innocent mistake. And that's where I want the law to be able to say it's been escalated to a felony because of prior driving history, because then it gives more of the full facts of the likelihood of how that driver would turn a corner, because he shows a pattern of careless behavior on the roads. And it is because it wasn't a felony that we had little room to bargain with. If it was a felony and we have up to 20 years and the negotiation for a family is far greater. We also personally, I didn't want photos of my mother laying dead out in the courtroom for the public to see. I wanted to reserve some dignity for her. We know his car struck her and she is dead because of that. We didn't need some jury to tell us yes or no about that. We wanted to get in front of the judge, who she now has, and she's the one who ordered the PSI report because she's the judge that let him walk 5 weeks before that on probation. So it's not this 60 days is what the prosecutor and the defense agreed to. And the only reason I said yes is because I've been told that through victim impact statements and the such prior records, the judge can increase that penalty. But right now, all we're giving her is up to 12 months. And I can just say, if it was a felony, there would have been way more room for at least a somewhat stomachable amount of time for the family. But yeah, I can say that I didn't really want to sit through a homicide trial and watch him act like he was, oh, I just made an innocent mistake, and them not being able to know that his pattern on the roads makes it quite likely that he would turn without looking.
Yes. Representative Kelly.
Thank you, Mr. Chairman. To follow up on what Co-Chair Washut had said, just so I'm understanding this clearly, under the current law, there was no opportunity to take into consideration a past history of reckless behaviors. They had to just take this one incident on its own merit under the law. And so I'm asking, you're saying here, if we add that flexibility, the ability for a judge to take into consideration a past history of dangerous behavior, which starts pointing to it's not a matter of if this person does it, but when. Is that what we're asking for here? And the reason I'm asking that is we live in the same town. My children walk the same streets. I have a son with Down syndrome. So this nightmare scenario your family's gone through, it's horrific for me to imagine myself. So that's all we're saying here. We're talking about adding for the legislature to add some flexibility to the judiciary to be able to make these determinations and consider circumstances beyond the incident itself.
Ms. Gladden.
Chairman Olson through to Representative Kelly. Yes, that's, I believe, like what I'm asking for. And I know Mike Cusick here has some more to add to that as well. But I believe that just because driving is such a patterned behavior, I don't understand why the record isn't put into it to, as Mike said, because I think the bar for recklessness is so high. And then the only other thing is a DUI. It's like there's people that fall between that are causing, trauma and deaths and harm on our road. And you look at this driver's record, he doesn't learn much from light sentencing. And I want the opportunity for the prosecutor to factor it in and be like, maybe this is some time where we actually hold him accountable and give some family some sort of justice. I know there's no amount of time that brings my mother back, but there is a certain amount of time that at least shows respect to her life and the fact that it was lost. Can I pass to you for further comment?
Sure, thank you. Chairman Olson, Representative Kelly. You know, one of the things we think about at my organization, again, we lobby on behalf of safe communities for bikes and pedestrians, vulnerable road users. This is a deterrent as well. I have a daughter, I have a grandson and a granddaughter on the way, and I think about, like I said earlier, a crosswalk. I mean, what in the world are we talking about here? Why, if you can't slow down, take the time to recognize if someone's there, how is that just a slap on the wrist? That's, in my opinion, this is just Mike Cusick talking, also representing this organization. It's the epitome of disrespect for human life. These are places that are put in place for that very purpose. And so we're looking at further definitions as well to include distracted driving that could include cell phone use, which we can track. You could also have other things because we don't know the distractions that are coming down the pipe for future drivers. We didn't have cars with 16 screens in them 5 years ago. It sends a message, I think, as well. There's a lot of folks in Wyoming who are coming here as tourists, who are coming here to enjoy our towns. Kate made a great point, and someone else echoed it in the hallway. Sheridan's a very walkable downtown. We would love it if all of our downtowns were that way. If we have people coming here for bike tourism, which we are actively invested in, who want to walk to your shops, and the message is this is one of 4 states where you can get killed by a driver and it's going to be a slap on the wrist. And I'm being extreme here, but you understand my argument. I think we need to send a message that this state benefits and we all are better off when we have that tool in the toolbox that sends a message. If you're going to be a driver who's not paying attention, especially when it's a crosswalk, there better be an awfully darn good reason we're not throwing the book at you.
Thank you, Mr. Chairman. As far as distracted driving goes, what recommendations do you have to guard against an actual tragedy? I think of my daughter with my grandkids, you know, my granddaughter taking off her diaper and hitting her brother in the head, and my daughter's distracted at that moment and a tragedy occurs. What recommendations do you have to make sure that this is truly targeted towards people who we might deem a danger to the general community and a one-off tragedy?
Yeah, Chairman Olson, Representative Kelly, I'm not an attorney, but I believe that that would rest with the hands of the prosecutors. I don't think it's a wide open door. Obviously, there's many scenarios where we would all understand that it's just an awful tragedy, but I think Kate said it well too. I think you know it when you see it. I think you try something and you find out if someone's on their phone, which is trackable all the time while they're driving. That's very different than I had to reach over and prevent my kid from jumping over the back seat. But I do find in our state, since we pay attention to this, and I look at things happening nationwide where bicyclists and pedestrians, because again, of size of vehicles, of speed, of number of drivers, et cetera, it's not a good picture. I'd like to think that we are better than that in this state, and I'd like to think we can raise the bar to match the trends in technology and to match the trends in vehicle size, as well as welcoming people who come here as citizens, residents, long timers, and visitors, that your streets are safe to walk and bicycle.
Can I add one comment to that, Representative Kelly? Oh, Senator Chairman Olson through to
Please go ahead.
Representative Kelly. Sorry. I just want to say personally to your point about like the genuine accident and thinking about your kids as they're learning to drive on the roads. Like where my mother was killed is actually down the street from the high school. And so when it first happened, we thought it might have been a high school kid. And I can tell you, I wouldn't be sitting here today if this was the, high school or a law-abiding citizen's first mistake. I thought, okay, this is my ultimate test in life at forgiveness. But then you see a record like this and the law just keeps turning a blind eye to it. I'm like, I need to stand up for another family. My sister was killed on the road 13 years ago. We know trauma and grief and struggle. And I also know when a change needs to happen, and so that's why I'm here. I do want to say we did factor in that more, at least personally for myself.
Senator Kolb.
Yeah, thank you, Mr. Chairman. So sorry for the loss, Kate. Yeah, sorry. The question I do have, a couple of them. First one is does this person still have a driver's license?
Yes.
And a follow-up question, Mr. Chairman. Yeah, and to think that we could increase the penalty to some, I don't know, say life in prison, I'll just say some crazy number. Mm-hmm. And that's going to deter people from doing bad things is really not reality. It doesn't work like that. I think if there's a hole in the law where the penalty doesn't fit what happened to somebody, that's an issue. But to think for one moment that stiffening up these laws are going to change the mind of somebody who's like this, with this kind of record, it isn't going to work. I'm sorry to say that, but sorry for your loss again, and appreciate you coming in.
Chairman Olson, make
Mr.
a
Cusick.
comment?
Sure.
Chairman Olson, Senator Kolb.
I didn't hear a question, but we'll pretend there was one.
Yeah, I just wanted to, if you don't mind, I'd like to comment
go
on that. I think you're right. There are folks who just don't change, Senator Kolb, but I think that what we're also looking at are the incidences where it's happening because people are, again, being heavily distracted. And we're so used to being on our phones. I challenge you to go out and stand in any street in your town and just look, especially when school's starting or letting out. In my neighborhood, it's this all the way to school, all the way down 4 streets to the high school from where I live in Lander. And so I'm looking at this from not just Kate's tragic and awful experience and all she's gone through in her family, but to protect vulnerable road users from an ever more distracted driving population. Not looking for anything draconian, not looking to be overly punitive, just letting folks know that if you're driving a heavy vehicle, if you're driving a 2,000 to 4,000 to 6,000 pound vehicle in the streets of Wyoming, and you choose to distract yourself from that, you might face a felony.
Representative Kelly.
Thank you, Mr. Chairman. I agree with the comment that we had earlier that some people cannot be deterred by the law, obviously. But would you say, either of you, that our town would be safer when somebody who's shown a pattern of reckless behavior, putting people in danger, is incarcerated? Are we better off when that person is not out in public driving?
Chairman Olson, through to Representative Kelly, you took the words out of my mouth right then. I would say, okay, he might not change his behavior on the other side. We actually can't predict that either way, but I can say for certain that incredible communities like Sheridan are far more safer when people like that are behind bars. I don't want to speak too much to it, but I know there's people that do feel unsafe and they might get an opportunity to take care of themselves and make different decisions while people like that are behind bars. So I absolutely stand by. We need to ensure that, I guess the charge and the amount of time that they're incarcerated not only fits the devastation that they caused, but does try to teach some accountability. Sure, there won't be some that change, but lives could be saved because of their time away, for sure.
Additional questions, committee? I appreciate both of you. Thank you.
Thank you so much.
Are there any state agencies wishing to testify? Looks like Ms. Hackle's making her way up here for I'm assuming for the County Prosecuting Attorneys Association. Welcome, Ms. Hackle.
Thank you, Mr. Chairman, members of the committee. I was planning on being second chair, and Sublette County Attorney Clayton Milankovich was supposed to be here. Unless he's invisible, I think I must be it. So thank you for having us here. This has been the subject of some email strings of discussion between the county and prosecuting attorneys. And I know that, like many of you, I have some personal.
Ms. Hackle, just so the record's clear.
Yes, of course.
Your-
My apologies.
Introduce yourself and the association you represent.
I
Sorry.
just like to jump right in. You
That's
know
all right.
that, Mr. Chairman. Members of the committee, my apologies. My name is Sylvia Hackle. I'm the district attorney here in Laramie County. I'm also a member of the County and Prosecuting Attorneys Association of Wyoming. And I don't know, I'm not seeing any other people. I guess I'm point for
You're
today. And I will tell you what some of the comments have been from my colleagues. I will also tell you I have some personal experience in this, in that fortunately it was not a homicide, but my daughter was rear-ended by a distracted driver doing 65 miles an hour in a 40-mile-an-hour construction zone. Destroyed her car. Had I been with her, I might have been killed because of the way the car crunched up. And she was injured. She was hospitalized. Her car was obviously destroyed. And the driver got a $165 careless driving ticket. Now that was Colorado. And I don't know how it would have been handled in Wyoming. But I certainly felt that distracted driving was not afforded adequate punishment. Also, my daughter annually participates in the walk for the young boy that was killed in the crosswalk here. And she feels very strongly about supporting changes to the law for distracted driving. And I do too. The way that the conversation between the prosecutors has gone is this. We all think that there are indeed times that the conduct which fits the statutory definition of negligent, we wish we had the tools to charge it as a felony for the reasons that you heard here today. People who drive distracted, drive drunk, drive with suspended licenses, all the things you've heard here today, don't seem to be deterred by those sorts of punishments that would certainly, I wouldn't drive without a license because I'd be convinced I'd make it 1 block from my house and get arrested. Other people, recidivism is something we live with on a daily basis in a prosecutor's office. So there are a significant number of the prosecutors who do support giving us the additional tool, as has been referred, to charge some of this conduct as a felony. Also, we struggle with the statutory definitions between negligent and reckless. Sometimes that's almost like what might be negligent to me might be reckless to Representative Chestick. I mean, the statute says one thing, but again, there's some room for interpretation. So I think that looking at the language you would suggest and moving forward and discussing it would be welcomed by the majority of the members of the Prosecutors Association. It is something we can look at and perhaps another tool we can use. This is a very frustrating situation, and you are all absolutely right when you talk of distracted driving and how do we deal with it and how do we try to restrict it. I also agree with the comments that were made that deterrence doesn't usually work. In my many years of practicing law, 12 of which included as a public defender, I've never, ever heard a criminal defendant say, you know, I was thinking of committing that offense, but I knew what the penalty was, so I stopped. No, what they regret is getting caught. And then when it's time to impose the punishment, they want something lesser than the maximum. And I've represented people on death row, and those individuals never said, I considered the possibility of being executed and chose not to do the crime, because I wouldn't have been representing them if they hadn't already done the crime. So from that perspective, deterrence doesn't work, but from a public safety perspective, it absolutely works. And yet, I'll be honest, and if you had a representative of the Department of Corrections here, they'd tell you we can't jail our way out of this one. I don't know why the situation in Ms. Gladden's case is being handled the way that it is. All I can tell you, there are extraordinary factors that are considered in every sentencing. Chances are quite good the judge can consider the defendant's background, even if it's not something that would come up in the charging. In other words, if the previous behavior doesn't add to the charging decision, it can nevertheless be considered by the judge in a sentencing context. So that, in response to one of the earlier questions, we don't need a legal change to allow that to occur. Where this would affect is what the prosecutors can charge. So I can certainly speak for myself that should you proceed with some changes to legislation, I would be happy to look at that legislation, and I'm sure the prosecutors that we would consider it, we would exchange it on our listserv, we would talk about it at our monthly meetings and provide you with input. And I'll stand for any questions.
Ms. Hackle, have you had a chance to look at Mr. Cusick's legislative ask?
Yes.
Let's talk about those aggravating circumstances that he's suggesting that we add to 6-2-106. And I want to know your opinion of those, the list. If there are things that we should prioritize from that list, things that maybe we shouldn't consider, things that we should narrow down, like distracted driving is you could drive a bus through distracted driving. What does that mean? Is it the mom who is distracted by her kid in the back seat, or is it the person who's texting on their phone while they drive through the crosswalk? I mean, those are two very different circumstances. So what would you feel comfortable with as a prosecutor?
Mr. Chairman, members of the committee, I think, first of all, you're right about distracted driving. That's going to be very hard to narrow the definition so we don't penalize, the mother reaching out to stop the kid from unbuckling their seatbelt and leaning forward, which, by the way, we all know kids can do that. For that matter, if you have a relatively new car, have you tried to change your radio station without taking your attention from the road and looking at that silly little screen? I long for the day of buttons. And so whatever station pops up on my radio stays there till I get at least to a stop sign, because I'm not going to go down the road going like this. So there's a lot of ways to be distracted. So yes, I think that that definition will need to be carefully crafted. I think texting while driving, which you're already not supposed to do, would certainly be one of them. I don't know the best way to define, I hate to use this word, negligent distraction, because we already have the word in the statute. And I guess I would say to all of you to think, have you ever, you were driving, let's say, to a store, but you'd swear your car thought you were going to work and you end up elsewhere. So we all do this. And that's not to cast aspersions. That's reality. That's human nature. So carefully crafting that definition is going to be important if we're going to use it to enhance penalties and to impose criminal responsibility. I would say.
Yeah, the hard part is trying to expand the statute, because the statute allows for a felony when you're operating a vehicle in a reckless manner.
Yes.
And so the question is, if I'm texting in a crosswalk, is that enough to say reckless? Is that, you use the word negligent. I think we would all agree that's negligent, but is it enough to say that person is driving in a reckless manner? And so I think when the statute was originally written, this concept of reckless driving was meant to be probably a more encompassing part of the statute. It was meant to give a lot of prosecutorial discretion to try to capture as many of the bad actors as we can. But apparently driving in a reckless manner isn't capturing all the bad actors.
Mr. Chairman, I'm not sure if it's not capturing it or if we see so many more variants of that behavior that it's hard to know. Like, I'd be willing to bet that at the time the statute was originally drafted, texting wasn't a thing, is my guess. Now you're right. People will text me while I'm driving. I just don't respond. But then people will say, you didn't respond to my text within 10 seconds. Well, no, I was responding, and I won't even respond with the voice app because that's distracted. So do I think a lot of that discretion is there already? Yes, I do. But I think if you specified certain conduct that you wish to be included within that definition, it wouldn't hurt, but it wouldn't remove the prosecutor's discretion. I think, and now I'm sort of speaking just for myself, but I think that the second and third items that are in the legislative ask are certainly reasonable. They impose a heightened penalty for repeat conduct of a serious nature. The fourth item, I would request a very careful definition. What is who are dangerous traffic offenders? That's kind of a broad term. But then the parenthetical comment, prior reckless driving convictions, something that is specific to that nature would also be helpful. Like I said, the individual's record will be considered by the judge in sentencing. The question is, as I understand this ask, and as I understand the testimony that I heard a few minutes ago, it's to expand the options available to the prosecutor at the get-go. I would add one matter, and we do have law enforcement here as well, although I don't know if they're here for this matter. So much of what we see as a prosecutor depends upon what we get from law enforcement, and it's usually superb. But it does vary. The situation in Cheyenne was concerning. I'll just leave it at that. So, we can only prosecute what we find out about. And by the time law enforcement gets to a scene, some defining information may no longer be available. So it takes all of us working together. But I would not object to having additional options available to me.
Yes, Senator Kolb, and then Representative Chestik.
Yeah, thank you, Mr. Chairman. Just I guess a question. As a prosecutor and you find someone kills somebody and say they're texting, why is that even a question about a reckless behavior? Because it seemed like to the layperson, that is a reckless thing that caused the death of somebody, whether you want to say, well, texting is benign or not. in certain circumstances. But the fact is there was a death. So tell me, as a prosecutor, what stops you from prosecuting that as reckless?
Ms. Hackle.
Like,
Mr. Chairman, Senator Kolb, I don't think anything stops it. I think the question is, does the conduct which was reported more closely fit with the definition of criminally negligent in the statute or with reckless? And every situation is different. So do I think we could? Probably. I'm trying to think if we've had a recent situation like that. I can't think of one recently that involved that scenario, but I'm sure there have been some.
Representative Cheswick.
Thank you, Mr. Chairman, and thank you for being here, Ms. Hackle. Just a question for my own mind. I never did criminal law, so I'm not an expert in that area. But it seems, my question is, how much would this bill, we don't have a draft, but the ask, how much would that change the actual trial, if any? It seems like what this bill ask would do would give the prosecutors a lot more flexibility in charging decisions and give them more room to negotiate during plea bargainings, things like that. But does it change the trial at all? I can't imagine that a judge is going to let evidence of prior convictions into evidence. That's not going to be part of what's going to go into the court. Does this change the actual trial at all, or is this just behind the scenes office work that the prosecutor has more power to reach an appropriate resolution?
Ms. Hackle.
Mr. Chairman, Representative Chesnick, it depends on, well, how the statute turns out to be drafted. But every time we take a case to trial for any offense, we have what are called the elements of the crime. And we get to prove those to the jury, and they get an instruction that says on this date in Laramie County, the defendant did the following things. And if it was charged as a aggravated homicide by vehicle because the person was, let's say, driving on a revoked license. Let's use that example. If that was an element of the offense, certainly as a prosecutor, I would argue I get to provide evidence of that to the jury. Now, do I think defense would argue against it? Absolutely. And there are rules of evidence that come into play. So it might cut both ways. But if it's an element, if it's a statutory element of the offense, I would certainly argue as a prosecutor, I get to produce evidence of it. So I would try.
Please.
Alternatively, some of the stuff would be presentable to the judge after the verdict. And it certainly has impacts on the sentence and the culpability that the judge has to decide at sentencing. So some of whether it's an element or not, still you have to go to the judge and present the fact that the prior convictions, for example, that doesn't go to the jury, but it does go to the judge. That still takes that into consideration, right?
Mr. Chairman, Representative Chesnick, absolutely. And I believe that's the case even today, without any legal change, that evidence of such behavior on the part of the defendant would go in front of the judge for sentencing purposes.
Oh, Representative Bratton, welcome.
Thank you, Mr. Chairman. I just have a question about the word suspended, driving on a suspended license. Does that also include someone who's forgotten their renewal, or is that deliberately suspended? Is there a difference legally there?
Ms. Hackle.
Mr. Chairman, Representative Bratton, I think as a lawyer, I'm allowed to say I don't know. But I think suspended means an affirmative decision by the Department of Transportation to suspend that person's license. I think if you fail to renew your license, you just have an expired license. That would be my argument.
All right, thank you.
Representative Filer, didn't you have a question earlier, or was it all answered?
You and Representative Kelly helping me out.
Okay, all right. Co-Chairman Washit.
Thank you, Mr. Chairman. Ms. Hackle, glad to have you here today. So I saw in the news just recently where we had a case where someone was charged with aggravated vehicular homicide. And somehow the jury found him not guilty of the aggravated vehicular homicide, but did find him guilty of reckless driving as a lesser included. To me, that didn't make any sense. How, if you had the reckless driving and it led to the death, but aside from the point, when it comes to things like cell phone use or eating a cheeseburger or changing the radio station, if an officer were to cite the people without a death, right, texting and driving, and they arrest them and charge them with reckless driving, would your office prosecute that driver for reckless driving when the only element was texting while driving? Because it seems to me the difference between texting and driving and causing a death and texting and driving without causing a death is whether or not somebody was in the crosswalk, right? That the behavior we see all the time, right? We talk about a number of people driving by the high school with their phones and the level of distracted driving that occurs, a small fraction of which might actually ever get enforced with a traffic ticket. But would your office actually consider charging somebody for texting and driving that didn't involve a crash with reckless driving?
Ms. Hackle.
Mr. Chairman, Representative Washit, if the case came to us, I'll be honest, most of those will go to municipal court and be tried as traffic offenses. But that's usually if they're arrested by Cheyenne Police Department, they usually take cases to municipal court. If for some reason that is an offense that is caught either by the Wyoming Highway Patrol or the Laramie County Sheriff's Department, that would come to us and we would certainly look at it. I can't think of one that we've done recently, but that doesn't mean it isn't there. I have to be honest and say, we run about 4,000 cases a year. So could one of them have been a reckless driving? Well, in fact, I know we do reckless driving cases.
Representative Washington.
Let's assume tomorrow you get a case, or Monday morning to Friday morning, and you're in your office. And the case comes to you charged or with a recommendation of charges by Highway Patrol for reckless driving. And the only violation that's taken place was the trooper saw somebody texting while they were driving. No other factors, just texting and driving. As a prosecutor, do you believe that can or should be prosecuted as reckless driving?
Ms. Hackle.
Mr. Chairman, Representative Washit. My initial reaction is yes, with the caveat that, of course, the circumstances would have to be looked at. But then I wrap in all the discussion you've already had here this afternoon about deterrence and getting the attention of distracted drivers. And if we don't get their attention at this less serious level, do they just escalate? You heard the story of someone who clearly did. So I say yes, knowing that as a prosecutor, there's always lots of factors to consider. And I hate sounding wishy-washy, but that's just as honest as I know how to be.
And that case gets pled out to a careless driving ticket, probably.
Quite possibly, Mr.
Yeah.
Chairman.
Senator Crago.
Not a question for Ms. Hackle, but I just was going to point out, I mean, if you go look at the definitions and the difference between reckless and careless driving within the statutes, I mean, reckless requires almost intent. I mean, it requires a willful or wanton disregard, whereas careless driving has a much lesser standard. And so I think, you know, back to our original case we're talking about today, I mean, that's part of the problem with the reckless driving statute and the definition that we've created over the years. So anyways, something we might look at as we're doing all of this is that is a pretty high standard. Reckless driving is a pretty high standard. So it's probably why the case went the way it did, because that is going to be really hard as a prosecutor to prove. So just pointing that out. Thank you, Mr. Chairman.
Well, I think that's actually poses an interesting question about the existing statute, because I understand what you would have to prove reckless driving versus careless driving. But for the aggravated circumstance of the felony in the statute, it just says in a reckless manner. So what is that? Is that the same? Are they the same elements, or what exactly do you have to prove reckless manner?
Mr. Chairman, I don't know the answer to that. I think that's another hole. I mean, there's a different definition of recklessly within Title VI. I think in 611 or somewhere 61104, there's a different definition, which is, bear with me. Recklessly is defined as the following conduct. A person acts recklessly when he consciously disregards a substantial and unjustifiable risk that the harm he is accused of causing will occur and the harm results. The risk shall be of such nature and degree that disregarding it constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. And I would comment, good luck proving that as a prosecutor as well. I mean, that is very, very distinct. I mean, there are 20 elements in that one paragraph that as a prosecutor, you're going to have to go attack. Not a good idea. I mean, I think we've obviously discovered a hole that we need to work on and fix. And so anyways, I'm just pointing out all of these different things in the statutes that make our prosecutors' jobs more difficult than they need to be in this particular situation.
Yeah, it seems to me like maybe I'm just thinking through this statute. There are different ways to approach it, but maybe that's the definition of recklessly. Maybe something we could approach is to define reckless manner in this statute and then list some of these aggravating circumstances that we believe constitute a reckless manner.
Mr. Chairman, that's definitely a possibility. And Mr. Chairman, if I might follow up on Senator Craigo's comment, you hit the nail on the head. That is quite the definition and therefore quite the challenge as a prosecutor.
Senator Craigo?
And Mr. Chairman, I don't know. I mean, as we work this issue, and maybe we just get away from the word reckless or recklessly altogether and just delineate exactly the things we think would qualify as an aggravated vehicular homicide. And that just don't use that term because it's going to create confusion anyways. And we just delineate, here's the 5 things or 4 things or 10 things or whatever the number is. We just delineate them within the statute explicitly. If you're doing this and you kill someone with a car, it's a felony.
I
like
that. Any other questions for Ms. Hackle? All right, we really appreciate the dialogue. Thank you.
Thank you, Mr. Chairman. Appearing in front of you always reminds me of why this is the practice of law. There's always more to learn.
Yeah.
Thank you.
And that's why we get CLE credit for being in the legislature. Because we never stop learning. We do. It's a 100% exemption.
Yeah, if I were admitted to practice, I'd like that.
Yes, it's quite nice.
We like it for sure.
Yeah. Anyway, additional testimony on this topic. Law enforcement, yes. How could we forget?
Now for the hard questions.
Yeah.
Thank you, Mr. Chairman. My name is Alan Thompson. I'm the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. And I guess I would just have some input on these 4 points from the recommended changes to the statute. And a lot of great discussion today. I just want to point out from a previous question that there is a separate statute in Wyoming for no driver's license. So if your driver's license is expired, that's a no driver's license. It's a less of a crime, less fine. And a suspension or a revocation is a much higher penalty, and it is done for some sort of driving reason. And as we look at the number 1 point on there, distracted driving, for example, texting or phone use, I would like to point out that the texting and driving statute in Wyoming state statute means texting, not using a phone, not dialing a number and making a phone call. That's legal in Wyoming. There are ordinances in the state that prohibit phone use, but as far as state statute goes, if you went that route, you would maybe want to look at, you would have to prove that a message was sent or received. And that's kind of a high burden for the law enforcement on the scene. There is information that we can get from a phone later on, but then you'd have to correlate the exact timing of things to make those be an indication of the crash time frame and so forth.
So would it just be easier to for you to just say phone use, the use of a phone while a death is caused?
Yeah, Mr. Chairman, anything that would make it easier for the law enforcement officer to know what they need to gather for prosecution and referring to the existing statute would be difficult. So any kind of phone use would probably suffice and be easier to prove. On that point too, we talked about the suspended or revoked license. I would also maybe add that for a point of consideration, failure to comply with or use an ignition interlock device, I think rises to that level of what a DUS and a revocation would be. And something, if you were going to use that point, maybe consider the ignition interlock device component of that also. And I put
Senator Kolb.
Yeah, thank you, Mr. Chairman. Just a quick follow-up on the phone use. What do you think about? You have to exempt hands-free, or the new way of like not touching your phone, just like there's a new way of changing stations on your vehicle. But what do you think about that? Should that be incorporated in there as an exempt situation? Thank you, Mr. Chairman.
Mr. Thompson.
Yeah, Mr. Chairman, I think most of the ordinances in the state of Wyoming that prohibit phone use do exempt the hands-free. In my experience with other states, it's a standard exemption is the hands-free usage. Mr. Chairman, I did add kind of a 2A. There was some testimony we heard this morning about basically the impact of a pedestrian in a crosswalk. I would like to also point out if that's something you consider, the definition of a crosswalk in Wyoming is both those corners at an intersection and the ones that are marked. So if you're referring to a crash that happens in a crosswalk, you might look at the definition of crosswalk under 31.5 because they're not always marked. And that about those 4 points is all I had, Mr. Chairman. And I don't think it's the right time to change the subject, but there is, since we're on the topic of DUI and vehicular homicide, I have a consideration for the committee that is similar but separate.
On DUI?
Correct.
Yeah, we'll take up DUI separately.
Got it.
Just so we don't
I understand.
confuse the committee with. What about this fourth point in the ask? To me, there's a difference between saying repeat dangerous traffic offenders, that's pretty wide open, versus a prior reckless driving conviction. What are your thoughts on that?
So, Mr. Chairman, from a law enforcement perspective, having the ability to know exactly what they're going to be prosecuting in court 6 to 18 months down the road at the time they're investigating it is very helpful. But that's not always the case. Sometimes we have a DUI where we don't realize it's a felony level DUI, and there's various other things that aren't available to officers at the time. So they would investigate the case like it's a misdemeanor. I would see this as more of that proper charging after the fact when you have all the evidence together. I would say that however clear we can make it on the front end helps law enforcement make that decision. Is there a custodial arrest that occurs right at that time? Does that then mean that their phone was on them at the time? It can be seized and preserved for evidence. So if we need to serve a search warrant on it, might be easier with that felony arrest at the time as opposed to a misdemeanor cite and release, and then scrambling to get that cell phone data at a later time. Maybe the probable cause doesn't exist to seize the phone and preserve that evidence. That's a combination between law enforcement and prosecution, and whatever we can do to make it as clear as possible on the front end helps law enforcement.
Co-Chairman Washit.
Thank you, Mr. Chairman. So I think you probably heard from my previous question. One of my big concerns here is that we probably have thousands of these distracted driving events take place every day. 99.9% of which never get noticed by a peace officer because we're spread so thin out there. What's been your experience with traffic enforcement generally as staffing issues have affected Wyoming law enforcement? Are we still writing the same number of tickets we did back in the day, or have those diminished as our staffing levels and workload issues have pulled our officers away from traffic enforcement? Because we're never going to deter the kinds of things that cause these tragedies without some enforcement. And that's my big concern.
Mr. Thompson?
Yeah, Mr. Chairman, I don't have data. I do know that when I have looked at some of those data points, you know, in locations, not necessarily statewide, there's a wave in there. You know, the traffic citations are up this year and down next year. Traffic fatalities are up this year and down next year. So there is kind of that ebb and flow. In my experience, though, agencies that have strong manpower, traffic enforcement is a really strong component of law enforcement, because that's a lot of your communities expect traffic enforcement. So there's a demand from your citizenry. And also that's a proactive approach to law enforcement that discovers bigger crimes, making that traffic stop, looking, you know, just to make a positive encounter with people for low-level traffic crimes turn into the discovery of larger crimes. So it is, I think, a constant focus of Wyoming law enforcement is that traffic component, both for those two reasons. But it is, you know, when you're responding call to call to call, you're going to drive by someone doing 8 miles an hour over the speed limit and not make a traffic stop because you're heading to a call, and then you're not going to, you know, find that DUS or the no insurance or the other things that might be going on in there. So I would, to kind of also answer that question, go back. There was some comment earlier today about deterrence. And I think that there's a general belief that just because something is against the law doesn't really deter people from breaking the law. I would say that in my experience in 25 years in law enforcement, I did interview various suspects that you know, said I committed this crime, but I didn't take it to the next level because I knew that was the difference between a misdemeanor and a felony. Your possession of controlled substance, third offense, is a felony. You're shoplifting over $1,000. There's a lot of deterrence effect in statute that this may impact. Like, for instance, if you make a focus on crosswalks, then maybe people won't pay a whole lot of attention on that random country road where nobody's at. And but when you're in town and there's crosswalks and there's marked lights and things like that, maybe there is a deterrence effect there.
All right. Thank you.
Thank you, Mr. Chairman.
Do you have any additional testimony on this topic?
Good afternoon, Mr. Chairman. Carl Germain, Lieutenant Colonel from the Wyoming Highway Patrol. I wanted to elaborate further on the distracted driving statute in Wyoming. From what I've seen in my career and with troopers that do try to enforce that law, as my colleague just testified to, if you stop someone that's on the phone and they tell you that they were inputting a phone number, typing in a name of a person that was on the phone, or contact or something to do with the phone call, it's generally not cited. I would also point out that to date in Wyoming, the data that I have available to me shows that we've lost 2 lives to distracted driving. I don't know what specific causes that they were. And I've heard some testimony and some conversation about what constitutes distracted driving. And so did a little research on that. And the National Highway Traffic Safety Administration, NHTSA, defines distracted driving as any activity that drives or diverts attention from the task of safe driving. This includes non-driving activity that takes the driver's eyes off the road, hands off the wheel, or mind off the road. the abbreviation for the Highway Traffic Safety Administration is NISTA. NISTA categorizes distractions into three main types: visual, manual, and cognitive. They break it down further. Cell phone usage would be talking, texting, or using apps is considered the most dangerous, as it combines all three types of distraction. Texting, sending, or reading text takes eyes off the road for an average of 5 seconds. And if you look at a speed of 55 miles an hour, that 5 seconds is equivalent to driving the length of a football field, to put that into perspective. Eating or drinking, focusing on food rather than the road. Adjusting the technology, so that's any of the screens and some of the apps that are inside the vehicle. Applying makeup, shaving, or brushing hair, otherwise known as grooming, and then reading any of the map navigations inside the car. In 2024, nationally, 3,208 people were killed in motor vehicle crashes involving distracted driving. And NHTSA also emphasizes, I know that we talk about the hands-free phone, but they do say any cognitive distraction or taking your mind off of driving can also lead to crashes. I would also point out it's federally required that commercial vehicles use hands-free devices. They're not allowed to input phones or interact with that phone in any way when driving down the interstates in Wyoming. That's a federal law, not a state law. And with that, Mr. Chairman, I'll stand for any questions.
Any questions, committee? Thank you very much. Any additional testimony on this topic? Do we have anyone online? Yes.
Mr. Chairman, we have Mr. Brubaker online.
Okay. Oh, I see. He's signed up for both topics. All right. Yeah, let's bring him in. Mr. Brubaker, welcome.
Good afternoon, Mr. Chairman. My name is Devin Brubaker, and today I'm appearing on behalf of myself and my family as a resident of Rock Springs, Wyoming. I want to be clear that my testimony today is that of my own and of no affiliation to the organizations I normally represent when I speak before you on other matters. I'd also like to first express my sorrow for Ms. Gladden and her family, and also say ditto to her entire testimony. I'd also like to ask that you do not see my remote testimony today and the lack of my in-person attendance as a diminishment of my message. I simply had other work obligations today. Mr. Chairman, on August 11th, 2022 at 10:32 p.m., my 27-year-old brother, Lamar Nate Brubaker, and his friend and business partner, 37-year-old Martin Whittier, were killed when a Freightliner box truck hauling newspaper rear-ended their car on I-95 in Delaware. Both of the men were influential filmmakers on the East Coast, traveling back from a business trip, and were working to revolutionize the film industry across the mid-Atlantic. However, their stories extend well beyond the successful careers. In an interest of time, I'll just assure you that neither of these men nor their respective families deserve to be robbed of what the future would hold. Throughout the multi-year investigation and criminal proceedings, it came to light that the driver of the commercial vehicle was utilizing his mobile device as part of a group video chat in the minutes leading up to and at the time of the crash while driving at over 70 miles per hour. There were no skid marks. There were no signs of avoidance. There were simply 2 lives lost, 2 kids that lost their father, a wife that lost her husband, and in my brother's case, a fiance that was supposed to be wed just 7 weeks later. What is even more troubling is that thanks to an unfortunate audio recording in that vehicle, Martin and Nate were well aware of what was about to happen, and we know that they saw what was about to happen while the driver that caused the accident did nothing to avoid it. You may ask, why am I here talking about an incident that occurred in Delaware? Mr. Chairman, is because Wyoming's laws are unfortunately just as antiquated as Delaware's in this space. After a grand jury was convened, an indictment of operation of a motor vehicle causing death, a low-level misdemeanor was handed down. By state statute, this indictment carried with it a maximum imprisonment of 30 months and a $1,150 fine per life lost. Mr. Chairman, the AG's office ultimately decided to settle the case and allow the driver to plea the case to a single count of operating a motor vehicle causing death. The sentence handed down for taking 2 lives while driving distracted on a mobile device was a measly $250 fine and 120 hours of community service. I think we can all probably say that we have at one time or another used our mobile device while operating a vehicle. If I asked everybody in the room, if I was there, to raise their hands to that effect, I think every one of us would raise our hands. I think the big difference is that if I asked a show of hands in the room of those that had driven while under the influence of alcohol or drugs, there would be far fewer hands raised. That is likely because many know the personal consequences of such action. When driving under the influence of a mobile device results in nothing more than a slap on the wrist, there's not enough incentive to avoid it to the general public. Mr. Chairman, I hope that my testimony today does 2 things. Number 1, it moves this committee and the legislature to strengthen the punishment for these offenses. Number 2, causes folks that are listening to realize that there are far bigger consequences to driving while under the influence of a mobile device than the measly criminal penalties currently in place. And let's be better than Delaware and the other states across the country that have yet to address us. This is a place where we can be considered a leader in recognizing and implementing needed reform. Mr. Chairman and committee members, today you can help move the needle forward to ensure that lives like Nate's and Martin's are spared in the future here in Wyoming. Mr. Chairman, I'd also like to address a question that was presented by your co-chair earlier in terms of why the plea deal. In my brother's case, the plea deal was because the prosecutor felt that the jury would be sympathetic, that because the fact that every one of them likely used a cell phone as they drove to the courthouse that day, they would see the defendant sitting in that seat as themselves and likely not be able to secure a win. And so, Mr. Chairman, along with Ms. Gladden and her testimony, I would encourage a stronger penalty, giving the prosecutors a tool in the toolbox that allows them and allows families to have a better conversation when the unthinkable happens. Mr. Chairman, I'm happy to stand for any questions.
Any questions for Mr. Brubaker? All right, thank you for sharing that personal testimony with us and really appreciate it.
Thank you, Mr. Chairman.
Do we have anyone else online wishing to testify? All right, we will close public comment on this topic. This topic's a little unusual because the way we have it is we've got several topics within the topic. So we'll discuss actions at the end of the topics all together, committee. We'll move to our DUI topic. I don't believe there's any material from LSO relative to the DUI topic. And the first person I have on my agenda is Mr. Stout from the Teton County Prosecuting Office. And it says he's in person, but he doesn't appear to be in person. Is he by chance on Zoom?
Mr. Chairman, I don't see him on Zoom either.
All right. Well, Mr. Thompson, do you have something? Yes, you did tell us you had something. That's right.
Thank you, Mr. Chairman. My name is Alan Thompson, the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. And we hadn't specifically asked this to be an interim topic. We were in discussions over the last year about maybe this being a hand-carried bill because it was a pretty simple concept. But I am able to provide this in writing for your next meeting if you want to consider this. I just wanted to mention that in 2007, we kind of had a rewrite of some of the DUI implied consent statutes regarding blood tests, urine tests, and breath tests. And the prevailing testing mechanism 30 years ago would have been breath and urine. And the advances in technology and the different types of controlled substances that we have, the preferred method now is blood test when you're looking for anything other than alcohol. And so in 2007, we had, prior to 2007, we had the implied consent. You were offered a breath test, and if you refused that, it was a refusal. Or if the officer suspected drugs or some other intoxicant, they were given the driver the choice between a urine test or a blood test. That's since changed to say in 316102, that ends with saying if the peace officer has probable cause to believe there is an impairment by a controlled substance, which is not subject to testing by a breath test, in which case a blood or urine test may be required as directed by the peace officer. So it says blood or urine test may be directed. However, 317307 is the implied consent requirements for commercial motor vehicles. And it has the old language in there. It says the person has the option unless the officer has probable cause to believe there is a controlled substance which is not subject to testing by a blood or breath test, in which case a urine test may be required. It doesn't give the officer that choice to select the blood for that testing purpose, and urine isn't likely to get us the information that we need. So it's a simple addition and deletion of 2 words, right? Basically moving it in the second part of the sentence. And I would be able to provide all of that in writing for your consideration for the next committee meeting to let the committee digest all of that.
I think that would be the best approach.
Thank you.
But are there any questions for Mr. Thompson? Co-Chairman Washit.
Thank you, Mr. Chairman. So my big concern about the blood test are the counties where we can't get a blood draw even with a search warrant. And I'm trying to figure out, in no other circumstance, when a judge issues a search warrant, do we allow the offender to say no? And we stop our efforts to execute the search warrant. We don't do that with anything else, but with blood. So when we have a vehicular homicide, a fatal case, 20-year felony, and we want that suspect's blood, we get it, right? 23 counties statewide. Is that true?
Mr. Chairman, Representative Washit, I don't know that I can answer that question right now. I do know that there's different direction in each county based on administrators of the law enforcement agency or the prosecutor in that county. It's not, I don't believe, consistent in all 23 counties.
Follow up.
Go ahead, please.
So my concern is that if on vehicular homicide cases, we take a more stringent approach to executing that search warrant and getting that blood sample than we do when it's a more routine DUI case. And so if your membership have any suggestions for how we might strengthen the law with regards to the execution of these search warrants to get blood from suspected drunk drivers when we've got a judicial mandate to execute that warrant, I'd like to see that in your email too.
Thank you, Mr. Chairman.
All right. Thank you, Mr. Thompson. Yeah. Oh, sorry. We might have a little bit more here. Representative Webb.
This isn't a question, more of a comment. I think that just for discussion's sake, this topic came up as a result of House Bill 192 that was presented in the last session.
Representative, is that Representative Storrs?
Stores, yes.
So
just
yes. So is the ask that you have different from Representative Storrs' legislation?
Mr. Chairman, I'd have to reread that bill.
Okay.
That was, was that the one that had to do with the refusal?
Yeah. Yeah.
Yeah, my ask is separate from that.
Okay. All right. Perfect. Then yeah.
More of a housekeeping of statutes to bring the CDL implied consent in line with the wording in the non-CDL, the regular implied consent.
Okay. Yes, please send that to us and to our staff as well. Okay. Thank you. Anyone else wishing to testify on DUI? Sounds like we will take more of that up at our next meeting. We have one final topic under this broader umbrella topic, and that is the Blue Envelope Program. So welcome, Representative Campbell. We heard an introduction to this back when we were considering interim topics, but feel free to refresh our memory.
Thank you. Thank you, Chairman. Thank you both, Co-Chairman and committee. Truly appreciate not only the opportunity today, but when we brought this to you in February, choosing to take it up as an interim topic. We are very grateful for that. I am joined with joining me today, I think online, I have Sarah Riley, who is the resident of Wyoming who brought this to our attention, and Lieutenant Como, who is from the Sweetwater County Sheriff's Department. So if I may provide a little background and then hand it off to them.
Yes.
So my name is Representative Elisa Campbell from House District 56. And we bring this to you, I have to admit, from the very beginning, when Sarah brought this to me, I didn't know what it was. I had no idea what the Blue Envelope program was. So did some research into what it is and the purpose and intent of the program, and the value, the benefits, right, to our residents. And what I have noticed in conversation is it tends to be much like the other conversations under the mental health umbrella, whether we're talking about suicide or any mental behavior health issue. In Wyoming, we tend to not talk about these things. We tend to be very, self-reliant, independent. We'll figure it out. I'll figure it out on my own. So we don't share those stories, whether it's the stigma or the narrative, but we don't talk about it. And what has been really, really cool is in having conversations about the Blue Envelope program and those that it serves, the number of people that have said, this absolutely affects me personally, affects my kiddo, affects pick a relative. So I've been really amazed at the number of people that have reached out and shared their story and said this absolutely personally affects me or my kids. So my hope is that not only do we have more of these conversations, but we make it more normal for people to share those conversations and talk about it more often and the challenges and the struggles that we face. So the Blue Envelope program really is a communication tool that will be of value, of benefit to our law enforcement officers because it gives them additional information. It communicates additional information to them before they enter into a situation. And so helps them be more prepared. It also helps our residents who are the users of this program to feel more comfortable, I guess, in anticipation of those potential interactions with law enforcement. Straight across win-win across the board. So if I may, Chairman and committee, hand it off to Sarah Riley first to talk about why she brought this to us and why it's important to her. And then we'll hand it off to Lieutenant Como.
That sounds perfect.
Thank you.
Miss Riley, welcome.
Hi, thank you all. Can you hear me okay?
We sure can.
Okay, thank you so much, Mr. Chairman and committee. I do want to just say, yes, I am in my car right now. No, I am not driving. The conversation was very important. Thank you to everybody for that. So yeah, I first became aware of this program probably about a year ago. There was a news article that came across my Facebook feed about a young man in Massachusetts who had worked really hard to find a way to be able to communicate with law enforcement that he has autism. And he was very afraid of maybe being pulled over and thought to be maybe uncooperative or belligerent or whatever else, just because he has a really hard time feeling comfortable speaking, especially with strangers and in a high stress situation. And I thought that was really fascinating that this program existed. And the more I looked into it, the more I saw, it's really efficient cost for a huge payout. My youngest child turns 15 this year. She is autistic and has anxiety, perfectly capable of doing a lot of things by herself. Very much looking forward to turning 15 this year and getting her learner's permit. But she doesn't like to talk to people she doesn't know. And so I'm afraid that even though she is very, very good at knowing the rules and following the rules, And I mean, she's probably, at least in terms of knowing the road rules, she's probably better than a lot of adults already. So I want her to have a good and safe experience. You know, and we all do things, you know, that we forget how fast we're driving. We have a tail light out. You know, at some point, everybody is pulled over for something, whether it's their fault or directly or not. And I just want to make sure that my daughter and other people in that situation have a way to clearly let law enforcement know when they approach the vehicle, hey, I'm not a safety risk to you. It might take me a minute to be able to answer your questions, but just know that I want to cooperate and I want to do the right thing and I want to keep everybody around us safe. So that is why I approached Representative Campbell to see if she would be willing to help move this forward for the people of Wyoming. So yeah, if anybody has any questions, I'm happy to stand for questions.
Any questions, committee? Yes, Representative Kelly.
Thank you, Mr. Chairman. Looking at this program, I understand it completely. I love the idea of it. We're talking about, actually, I should probably be doing this, right? We're talking about individuals who might be experience sensory overload with lights, yelling people, loud sounds, might be unable to comply with simple orders or answer questions and go into complete shutdown. I understand what this is. What are we asking from the state? This is a legislative committee here. Are we looking to fund this? What's a particular ask from this committee? Because the program itself, I'll say yes to, but I need to know what we're looking to do here as a committee.
I think that's, sorry.
You can certainly go ahead and answer that. I think to the extent you can, I think it might be a question for Representative Campbell, though.
That's actually exactly what I was going to say. I apologize. I just assumed the correct question was for me.
Yeah, no worries. We don't expect you to have all the answers. We appreciate you bringing the topic to us. Representative Campbell, I was wondering the exact same thing. I was just waiting for Converse County, or is it Sweetwater County? For Sweetwater County to testify, and then we have this handout from, I believe this is an active program in Converse County. So it sounds like it's happening. And so what exactly is the ask of the committee?
Thank you, Mr. Chairman. My ask, because I have, done some research, and there are states where the state has adopted the program, and then there are other states where just individual counties have, made the decision to use this program. The challenge I see, especially in Wyoming, the reason I brought it to you as a committee to look at is so that we could implement it at a state level and have the state of Wyoming adopt it. Primarily, so that we have awareness with all of our law enforcement that regardless of county or municipality, they're aware of the program. Because we have residents that travel that may be licensed in Cheyenne, but drive to Laramie. And so giving law enforcement in Laramie so they know what the program is, right? So when they see it, they know what it is. That's the first part, just so we have that awareness statewide. Second part is having this funded through Wyoming and the Wyoming Department of Transportation, so Department of Motor Vehicles, would be the source of, individuals when they go to test or want to voluntarily join this program. They would have access to those resources at the Department of Motor Vehicles. That I think shifts the burden from the individual municipalities and counties. I don't know as to how it would be a lot, but shifts that to the state because we would run it through the Department of Motor Vehicles. Those are my primary two reasons for bringing it to the committee to look at a statewide initiative.
Representative, is there special training that officers go through, or is it just as simple as creating this envelope?
It really is just ordering envelopes, and they even have decals. So you can just put the decal on your window, whether it's your driver's side window or your passenger side window. That really is just that indicator to law enforcement as they approach, right? That this is an individual. I've talked to both our chief and our sheriffs about the program, and there is no additional training because they already do all of the CIT training and the, de-escalation training. So they already have all of the training. It's just awareness of the program, and that when they see that decal or they see the envelope, is an indication to the officer, right? This is the individual, the situation that I need to be more mindful of. And then the training they already have comes into play. So there is no additional training for law enforcement.
So we've got kind of multiple levels here. One would be if the state adopted this, it would be something that our highway patrol would be obviously aware of. And we could have a statewide envelope, for example. And then, so do you envision it just being distributed from YDOT to the various counties and municipalities? Or do you envision funding going to those counties so they can create their own envelopes? What does that look like in the best way?
That would be one thing. I would, I guess, ask the, committee to look at what might be the most efficient, feasible way to do it. I would suggest that it is housed under the Wyoming Department of Transportation and Department of Motor Vehicles. Every municipality, every county, right, has an office. And so residents then would know, right? When I go to get my driver license, when I go to reissue my driver license, when I go to, that is a resource. Could there be additional envelopes or decals distributed to the counties or municipalities? I don't know what that would look like. But my recommendation, just in terms of effectiveness and the research I've done, would be to house it under the state. And so, yeah, DMV would provide those materials.
Have you had conversations with YDOT?
Mhm.
And do we have someone from YDOT here?
Mhm.
No?
Oh, Misty was here.
Oh,
Where'd she go?
yes.
I think we do.
Let's bring YDOT up. Yeah, you have a question for the representative? Go ahead, Senator Cole.
Yeah, I do, Mr. Chairman. Thank you, Representative Campbell. Are you already aware of any downsides to doing this?
Representative Campbell.
Mr. Chairman, through you. So Senator Cole, I'm not. I had conversations with both, primarily my chief of police, and said, what are your concerns? And he said that people who don't need this would take advantage of it. And I said, and what is the downside to that? And he said, well, there's not really a downside other than when the officer approaches the vehicle, they make the assumption that that is the situation, and then it turns out it's not. So it's having additional information that is not needed. So that was the only concern he had, because it is a voluntary program. And I mean, we don't track individuals or track data, pretty significant HIPAA violations. It is voluntary. And so that was his only concern.
Senator Cole.
Yeah, thank you, Mr. Chairman. Just to give you one, how about they get mocked? People see that in the window, and kids are pretty mean, to be frank with you. I see that as a huge issue. I think, there's risk to officers. Just another one. People can act out and then they drop their guard. I mean, there's all sorts of risks to this. I mean, I think it's not without risk. And isn't it true that the local jurisdictions currently now could initiate this program if they wanted to? There's nothing that stops them. I mean, as I understand it, what do you know about it? If you could explain, Ms. Representative Campbell, thank you.
Representative Campbell.
Thank you. Thank you for the question. Mr. Chairman, so yes, individual municipalities and counties could implement this. It's been done in other states. And if we look to Colorado, Denver, Windsor, Boulder, those three have opted to initiate this program. And because it is not statewide, then residents run into some challenges because it's not recognized or identified and handled in the same manner in other municipalities or other counties. So the advantage to having a statewide initiative is that consistency and that awareness of, which doesn't, prohibit counties from doing it now. I can't remember. There was another part to that. Is there another part to the question?
Senator Kolb, what else?
Yeah, thank you, Mr. Chairman. Danger to law enforcement. I think there's no criteria to get a blue envelope. Apparently you can I tried to read it. I didn't see anything. Maybe you could help me out with that. But it looks like you can just proclaim you need a blue envelope and get one. But, you know, once again, I just wonder out loud, are we doing something that's going to have a negative effect on safety because of this? I mean, I know we always look at the good side, and thank you for bringing this up because it obviously has a good side to it. But what do you think about the negatives? That was my more broad question. It's not all sunshine and rainbows out there. And so I just wondered if we thought this through enough to want a statewide program. That was my large question, Representative Campbell. Thank you.
Thank you.
Representative Campbell.
Thank you, Mr. Chairman. I'm not aware of potential law enforcement or, risks to our law enforcement officers. So I would defer to Lieutenant Como for that perspective. From the conversations I've had, that hasn't come up as a concern, primarily because this is a communication tool. It's additional information. So the conversations I've had with law enforcement is when they have additional information before getting into a situation, it is advantageous. So this just provides them with that additional information. Hey, here's what you're walking into. Adjust accordingly. So the conversation about risk or potential risk to officers hasn't come up in conversation. So yeah, I would ask Lieutenant Como for that.
Yeah, and Lieutenant Como, we'll get to you in a few minutes. I want to talk to YDOT first about administration, but hopefully you're listening and can address some of those questions for us when we do come to you. Co-Chairman Washit.
Thank you, Mr. Chairman. Just a quick question. What would be your thought if we were to take kind of an approach like we do with handicap parking devices to hang on your mirror or put in your car, where there's a process created, you get that emblem or that license plate or that hanger through your medical provider. Is that a big showstopper if the only way you got a blue envelope was by going through your mental health provider or your pediatrician or something like that, like we do with handicap parking? Would that be a showstopper?
Representative Campbell.
Thank you, Mr. Chairman, and Chairman Washit for the question. I believe, and I'm going to defer to Misty on this one, that we have similar alert systems in place for some of those medical alerts, that individuals can participate in that program. So law enforcement is alerted to potential medical. And I'm not sure what that process looks like or if it is a hindrance to. And I don't know how much this would complement that or could be used, in the same manner. I'm not sure if that, I don't believe, I've read anywhere that has been a requirement in other states or that they've implemented it that way. So I'm not sure how that would work.
Sounds like a perfect segue over to YDOT.
Chairman Olson, members of the committee, my name is Misty Zimmerman. I am the program manager for Wyoming Driver Services. First of all, I just wanted to thank the committee for the opportunity to walk through this. The Blue Envelope Program is in use in multiple states across the U.S. There are two schools of thought on it, similar to what Senator Kolb mentioned. One school of thought in the jurisdictions are that it could present potential hazards. The other school of thought is that it is wonderful and it is an amazing program to be involved in. That's a policy decision for sure from this body. Back in 2019, some of you may remember Cody's Law, which was created to do this exact or something very similar and may have opened up the door for programs like this to exist outside of the realm of the state. What that did is that allowed for individuals to designate a medical condition, and then we would have an indicator added to the front of your license, your driver license or identification card, that would then also be passed along to law enforcement through when they did an inquiry on your driver license or identification card. So that's sort of where we are at the state level. Other jurisdictions, other states are using the Blue Envelope Program specifically for it's symbolic of the autism or sort of the cognitive disabilities. I've seen other jurisdictions use a green envelope for hearing disabilities. So there are some really across the states, there are some different things. But I do feel that if it is that it is a policy decision by this body, and if we decide to do it either at the state level or not as a policy decision and the counties pick that up, YDOT would be a place that those envelopes could be distributed, because effectively they are for your driver license, for your insurance card. You could also utilize insurance agencies, all of the things. So I'm not sure exactly where that belongs, but I do feel like we did sort of open that door with the Cody's Law in 2019, which created that statute. This is sort of an add-on that would go along with it if a person chose to.
I might be alone in this opinion, hopefully not, but I would think it would be much more efficient to have YDOT administer it on a statewide basis rather than having 23 versions of the blue envelope. And then, because then you've got multiple levels of law enforcement. You've got highway patrol, you've got city police, you've got the sheriff distributing the blue envelope, and then they've got to know what 23 different envelopes look like and the colors. And I mean, there's just so much can happen if you allow this to be completely locally controlled. I don't think it works very well in a state where people are moving across county lines and cities and across the state. So implementation wise, if this were implemented by YDOT, what would be the blue envelope program? What would your involvement exactly look like? How do you picture it unfolding? Would you just create a standardized envelope that would be available to all law enforcement, or how do you envision that working?
Senator Olson, members of the committee, it becomes obviously we don't think about cost or the effectiveness or how much that is affects how we do that. But when you start talking about that across the entire state and where that belongs is completely up to you guys. I do see it landing. It is possible to land at driver services. But like I said, again, it could be distributed at your insurance agency. It could be distributed at your doctors. So we do make logical sense. Cost of the program also then becomes a question of where those funds come from. But we'll work through that process as we always do.
But at this stage in the game, you don't have any cost estimate that you could provide us, because we don't know exactly the direction we would take it.
Senator Olson, you are correct. The other one piece to realize is that as jurisdictions across the United States pick these up, it becomes a very commonplace, right? So me necessarily having oversight over 23 counties, you might have 51 jurisdictions that have a different blue envelope. So that is also something to consider as you walk through this and decide which direction that the body wants to go.
Okay. Senator Kolb.
Yeah, thank you, Mr. Chairman.
Sunshine and rainbows.
Just, yeah, that's lollipops too. The question would be is, when is a person disqualified from getting a driver's license under certain like autism situations? What is the criteria that we use in the state of Wyoming? That's my question. Thank you, Mr. Chairman.
Ms. Zimmerman.
Chairman Olson, Senator Kolb. So Wyoming is not a mandatory medical reporting state. So if a physician determines that a person is not capable of operating a vehicle, there is no requirement for that person to be reported to the state. We would rely on the observance of the individual as they visit my exam station. My examiners are trained to determine whether or not a person can successfully, either cognitively or physically, operate a motor vehicle. And then we would walk down that process of what a medical examination looks like, re-examination looks like. So there is no mandatory medical reporting for any reason in this state at this point.
Representative Filer.
Thanks, Mr. Chairman. Been quiet all day. But Representative Campbell, would it also, we keep talking about, driver's license, but this doesn't just affect folks with driver's license. This affects folks that are passengers in your vehicles, your children, teenagers. I mean, look how many disability providers that we have out there right now that have to travel with a lot of these folks and stuff like that. They could be triggered by the things that like Representative Kelly had just talked about, right? And I come to this, personally too, because my daughter's one of those. The right noise, the right light, erupt, you know, if you have to stop really quickly, anything like that could trigger her, start having seizures. She's nonverbal. So say later on in life, this could actually help the police officer there to actually help give her the services that she needs at that time to make sure that they understand what she is going through. So the negatives are, I understand what, you know, Senator Kolb has said and stuff like that, but I think that the positives of this way outweigh any negative. And I think that's what we need to look at also. It's not just for driver's license. And I can understand if we go down the DMV to grab these envelopes, if your insurance agent wants to go down, grab a stack so he can hand them out at their insurance companies, whatever it is. But having it at the DMV is probably the best way to go. But I don't think we just look at this as for people who are just driving, if that's the way you want to go with this.
Representative Campbell?
If I may.
Yes.
Thank you, Mr. Chairman. I've actually had several residents reach out to me when they heard about this and said, well, this isn't just for drivers, right? Because I have, and, you know, my daughter drives me, or, you know, my wife, husband. And that is the beautiful thing about the program is wherever, I mean, there happens to be a decal or a blue envelope, whether they are the driver or the passenger or in the back seat, wherever they are within the vehicle, it indicates to the law enforcement officer before approaching the vehicle. There is an individual within the vehicle, and so they automatically adjust to approaching the vehicle differently, being more mindful of, I might, you know, have interaction with an individual who is now dumping a ton of adrenaline and anxiety, and it may not be as able to answer questions, and to be mindful of why that might be, and to respond accordingly. So it really is a tool that will indicate to law enforcement that anyone within that vehicle, and to approach accordingly.
Representative Kelly and then Representative Lean.
Thank you, Mr. Chairman. Just clarify a couple of things here, because thinking about some of the concerns about safety. As somebody who's personally alternatively wired myself, I don't respond to touch well when I'm not ready for it. It's like an electric shock. I get that. But the other hand is you're handing out to law enforcement, do not touch. There could be safety considerations, whether to protect others or often to protect someone from themselves when they're having a meltdown like that. So how do we guard against, how do we let law enforcement continue to do what they need to do to protect themselves and others? Can we clarify that better?
Ms. Zimmerman?
Senator Olson and Representative Campbell, sorry if I think that's where we have to walk down what we've done in 2019 with Cody's Law and the House Bill 191. We will have a very large envelope very quickly if we are not careful about the things that we include in this program. So we have to utilize what is already in statute, which is the ability to designate a medical condition on your driver license that would allow law enforcement to be aware of certain situations like Representative Kelly was speaking of. My concern is if you start broadening past the intended purpose of the blue envelope, if a Wyoming driver goes to another jurisdiction, another state, or they're going to have different things. So I think it's really important that we keep it, if we do walk down this path, we keep it very specific to what the program was intended for. And also, we probably don't want to use the specific name because if it changes to the pink envelope in 3 years, it does that. So I think we have to leverage what we currently have in statute under 31.7.142 for the situations. And if we do decide to go down this blue envelope path, we work through that process separately.
Representative Lean?
Thank you, Mr. Chairman. Thank you for joining us today, ladies. My question is for YDOT. You have on here that you have on the handout that we were given nonverbal individuals, and I'm wondering if there are nonverbal individuals that are driving in Wyoming currently.
Chairman Olson, Representative Lean. The handout was provided to you by Representative Campbell. Yes, there are nonverbal individuals that do possess driver's licenses. It's dependent on how they are able to communicate with us. But yes, there are people in the state of Wyoming that do not have verbal communication skills.
Follow up.
Yes, Representative Lee.
My next question would be on this envelope particularly, it has medical here. Our current Wyoming driver's license, do they offer the opportunity to put medical signals on there for the officers if they pull somebody over and then identify them that way?
Ms. Zimmerman.
Chairman Olson, Representative Lee, that's what we were just, that was previously discussing, which is House Bill 191 from 2019. 317142 allows you for you to designate a condition, and then the symbol is put on your A symbol, not the symbol for the condition, but A symbol is added to your driver's license. That is then stored in our system and then is passed along to law enforcement if they do a run on your driver license.
One more.
Yes, go ahead, Representative.
Thank you, Mr. Chairman. My question now comes to oppositional defiancy disorder and individuals that have a true problem with authority. And while that would come from a medical professional for a diagnosis, my question is, at what point do we then begin giving them red envelopes or identification markers that say this individual is not going to respond well to authority versus this individual is going to have anxiety when you pull them over? As we're approaching the 14th Amendment and separation of class and different laws being for different people, I'm trying to get to a plateau where I can say, I understand what this program is trying to do, but I can't support it given the current factors. So is there a line in the sand that we're drawing so we're not putting a burden on our officers on how to communicate with different individuals differently?
Representative Campbell.
Thank you, Mr. Chairman. Thank you for the question. And that is exactly what this program is not, right? The intent is to give residents the ability to volunteer to be part of this program because they know, right, under certain situations, stressful situations, it might become challenging for me to interact appropriately with law enforcement. So it doesn't designate all of the different, I have this, I have this, I have this, doesn't do any of that. It just indicates to law enforcement that there is cognitive difference. And so that is when they rely on their CIT training and their de-escalation training, because they know, right? This individual might not respond in a normal fashion. So I need to be aware of that. It doesn't distinguish where they are, whether it's autism or, some other cognitive difference in how we respond to stimulation or a situation. Doesn't differentiate any of that. It just is an umbrella indicator to law enforcement. Yeah.
Representative Singh, you're here.
Hey, thank
This
you.
is the first time you've talked all day.
All day. I got so excited. I appreciate the intent of this blue envelope, and I'm just thinking about if an officer or law enforcement were to get this information, Representative Campbell, let's say they get this information, are our officers trained enough right now to handle interactions with the differently abled, the alternatively wired? And how can we support them as they encounter situations like that?
Representative Campbell.
Thank you, Mr. Chairman. Thank you for the question. Yes, they are. Trained and equipped to. This truly is, whether it's a decal on a sticker or an envelope on the dashboard, it just gives them a heads up that this is the situation, provides them with more information. So then they are ready and have that training. The other benefit of the blue envelope is it is a single location. Most of us, when I get stopped, and it's happened on more than one occasion, your brain gets a little frazzled, right? As you're trying to, oh man, what did I do? And it becomes challenging for any of us. And then add this additional layer can become even more stressful for the individual. So this blue envelope is the single location where they can have, their insurance and their registration and their copy of their driver license, or in case of emergency, contact this person. They can have all of that information that they're going to be asked for in this one location. So it removed the challenge of trying to find and think through, and it just makes it easier. It's all right here. It's all right here. So is a, benefit on both sides. Yeah.
All right, let's get some law enforcement perspective on this. We have Lieutenant Como on Zoom.
Yes, can you guys hear me?
We sure can. Thank you.
Good afternoon, Chairman, Committee. Again, my name is Rich Como. I'm a lieutenant here at Sweetwater County Sheriff's Office. I'm here to speak not only on the law enforcement side, as a father with a 16-year-old son that is autistic, and then also I'm an advisor on the National Autistic Safety Council as well. And so I believe some stuff was handed out to you. I just want to step back a little bit and just go over a couple stats and some definitions before kind of getting into things. So the CDC reported back in 2025 that 1 in 31 communities tracked by the CDC, 1 in 31 8-year-old children are identified on autism. 25 to 30% of autism individuals are non-speaking or minimally speaking. And then 31% of children with ASD have an intellectual disability of an IQ of less than 70. So kind of keep that those stats in mind as we discuss some of the questions you guys have asked today. The other thing I'd like to talk about is exactly what is the definition of autism spectrum disorder. That's the root of the blue envelope. I agree with some of what you guys are saying is expanding it out to maybe just cognitive or developmental disabilities or delays that can kind of encompass some of that, but I agree not to go too far out. But the definition of autism spectrum disorder, neurological development condition, a neural development condition that affects communication, sensory processing, social interaction, and behavior. I know Representative Kelly mentioned the overstimulated and the overload, sensory overload. That is a huge part of the interactions with law enforcement, whether it's the lights, the sirens, just the presence of the way law enforcement presents themselves and kind of that authoritarian figure could create that change in environment of a traffic stop or an interaction that may put an individual into, in their mind, the terminology of crisis. Now, we all have a little bit different terminology of crisis. And myself getting pulled over may not be in crisis. Does my heart rate race a little bit? A little bit, as Representative Campbell mentioned. I think we all kind of get that, shucks, here we go. I got pulled over. What did I do wrong? But it escalates it a little bit further in their crisis. When someone's in crisis, they may appear non-compliant, aggressive, or non-responsive. Doesn't mean that they're intentionally doing that as disrespect or defiant. It's just that they're overstimulated and overloaded in a sudden change in the environment that currently we're in. In fact, they're just unable to process as well. Again, you go back to the stats I just mentioned, what the IQ is, and the other stats kind of plays a role into that. The Blue Envelope program is a nationwide. Yes, agencies, Sheriff's Office, you got the handout, the Blue Envelope from Commerce County. I know Sheriff Becker's trying to implement that in his own county. I would be in support of the YDOT aspect to it too. It's a one-stop shop. YDOT already brought up the Cody's Law aspect from 2019. I think it just is the next step further in providing that information to law enforcement. And I'll even throw in any first responders because that envelope would be carried in a car. So if an individual was in a car crash, that information could be found by law enforcement or other first responders that might take that information and help whether de-escalate the situation. It has emergency contact information provided that could benefit the individuals in the car. I also agree that expanding it to not just the driver, but to the passengers. If I was driving with my son, I would have this in there, because if something happened to me while I'm driver where my son is still there, there's information that understands how to, again, that crisis, to help de-escalate. Yes, we are trained in CIT. However, the state of Wyoming, through the Peace Officer Standards Training, does not dictate a standard, or that Wyoming law enforcement has to have CIT training or any training in regards to de-escalation. There's not an actual standard, nor is there on the national level. So that's a whole nother can of worms, I think, maybe talk about later. So there may be agencies, smaller ones, that don't get it very often in the county. We're fortunate enough here in Sweetwater County where we get it every 2 years. I'm actually a part of that, where I teach interactions with autism. It mimics a lot of the other de-escalation techniques and tactics. It goes in a little bit more depth, specifically towards autism. So the training aspect for law enforcement, I would say yes, that there is a little training aspect to it. And it comes down to familiarization with the program. There are states, that are doing it right now. They travel through Wyoming, I-80, I-25, some of the busiest corridors of interstate. What if we pull somebody over and somebody produces this and they take it as, an officer right now doesn't know, or a deputy doesn't know, or our trooper doesn't know. So there is encounters that may happen already that we just don't know about. One of the things I've talked to through other agencies throughout the nation that do this stuff, they make it a fun. The agency can do it whether they choose not to want, but they make it fun where they do mock traffic stops, where an agency can have an event for local communities and do mock traffic stops. They bring in individuals that, like my son, who he has his learner's permit. He's still struggling with the driving concept a little bit, but it'd be a perfect opportunity for him to come in a controlled area, go through a mock traffic stop, what it would look like. Again, just like anything else, we practice sports, right? We go and we practice, the soccer, the wrestling, the football, whatever athletic or other activities you do. The more you practice, the better the habit is, the positive interactions happen. On the two side of that is you learn the individuals in your community that have disabilities and disorders. And so when future crisis happens that's outside of just a traffic stop, you understand how to engage that in a better and safer manner. Mentioned there were some questions about risk. Law enforcement, every traffic stop is a risk. It doesn't matter who's driving it behind that wheel. Traffic stops are one of the most risky things law enforcement do, whether it's on the interstate, highway, street, road, wherever that's at, because you just don't know who you're pulling over on that day and what they are feeling in that moment. You treat it as a traffic stop. This was just a piece of information to allow the traffic stop to continue the safest and most positive interaction as possible. The decals, it was talked about, kids being kids, mocking. My son has been bullied the entire time he's in school. Now, other kids may not know he's on the spectrum, but they know that he is, and I hate this word and I've heard it today and I apologize if it offends some of you, but the wired wrong. I don't think that's appropriate terminology, but kids knew there was something different about him and he'd be picked on to the point where right now he does virtual school. And it's not just because of the bullying aspect, it's other aspects. It's the social interaction aspect and some of the behaviors within a brick and mortar school, but I digress. The mocking, I don't think, if that's the case, don't put the decal on your car. It would be my suggestion. The handicap sticker, I know that was mentioned. I think that was covered pretty well by YDOT. I know it was brought up about, the passengers. Again, I think it's just another piece of information, not just for law enforcement, but like I mentioned, for other first responders, fire, EMS that have those interactions as well and just provides additional information. With that being said, I'll stand for questions.
Representative Ling.
Thank you, Mr. Chairman. Thank you for joining us today, and thank you for your patience while we were having a discussion here. My first one is the decal. Do you anticipate that the decal on a car may give human traffickers a new target?
There's nothing that says it wouldn't or wouldn't, so I couldn't answer that question yes or no directly. I know other states do not have a decal. There are some that use the decal. You know, human trafficking is one of those where, yes, they will take advantage of anything they can at any moment. You know, social media is their number one target of how to, groom or attract those individuals of human trafficking. There's stickers out there now. They're the ribbons of all the multicolored ribbons out there. There's one for autism. There's one for everything just about. I mean, you could say that would be a target as well.
Oh,
Go ahead.
thank you, Mr. Chairman. My question is, how do you handle pass-throughs now? People that come from Denver that may have a blue envelope system that are in your area. How do you guys handle those traffic stops now?
Lieutenant Como?
Mr. Chairman, Representative Lean, I personally have not seen that yet come through Colorado. I just brought this concept up in my training recently in-house and in our CIT last month. So I'm still waiting for some feedback from the patrol deputies that are out there. Like I said, I don't know how that would work. Hopefully now that they understand from the brief synopsis I presented them, that they would understand what that concept is.
Additional questions for Lieutenant Como? If not, we've got some more law enforcement perspective. Thank you, Lieutenant Como, for your testimony. We appreciate it.
Thank you.
Next, let's move to Sheriff Becker. And Mr. Thompson, do you have comments on this as well? If so, why don't you just come on up? Welcome, Sheriff.
Thank you.
This is your blue envelope.
Yes, sir. I remember how to run this thing. My mouth's loud enough, but I don't need it, but.
Just needs to be green.
Thank you, Chairman Olson and committee. I was asked to come down to speak with you about this.
Oh, Sheriff, can you just introduce yourself for the record?
Oh, yeah, I'm sorry. I'm Sheriff Clint Becker, Converse County Sheriff. Just so you know, because I think it speaks to us adopting this. I did up little over 20 years on the Wyoming Highway Patrol as a road deputy or trooper, I'm sorry, and I've been sheriff. This is my 20th year as being sheriff. So this was brought to me about 3 or 4 months ago by one of my deputies that had been in Colorado and saw it when she was down there and brought it back and says, you know, I see this. Looks like a really good program. So she gave it to the undersheriff, who's got more than 35 years as a Wyoming peace officer as well. And we looked it over and talked about it and said, you know what, that looks like a pretty good idea. So we implemented it. And it's pretty simple for us. I know there's been a lot of questions and it's gone down different roads here, which is good. But it didn't take us long to look this over, discuss it with our deputies and staff and say, what do you think about this? And we implemented it. We made, I think 500 copies and took the envelope from other agencies that have used the same envelope, put our emblem on it, have had nothing but positive response from the public. And, you know, if I look back as I've stopped thousands of people in over 20 years. And, you know, if somebody handed me this from another state, I'd never seen it before, I would probably look at it. And if it has their driver's license and registration and insurance information in there, boy, that'd be such a benefit. Because, you know, speaking for myself, when I made a traffic stop, I only asked for one thing. I wanted the driver's license because I wanted to watch them give me the driver's license, because I don't want to watch everything they do. Cause then they got to reach in the glove box for the registration or the insurance or every other place in their vehicle looking for that. It's too much for me to watch. So I asked for one specific thing, the driver's license. Besides that, I figure if something happens to me and I have their driver's license and they don't jump out of the car and grab it, then there's evidence there with me who might hurt me. So I don't see the concerns. I don't think that we'll go with the stickers. I don't think that's something that I'm gonna, I mean, I don't, if I pull somebody over and I love Jesus on the back of it, you know, I might be more suspicious of them of being willing to hurt me because, you know, I'm not gonna let my guard down for that. I don't, but if somebody hands me one of these, I've never seen it before, I look at it. It's got the information in there. It'll be helpful. I think it gives them a little bit of tips. I think people get nervous. People don't have all their stuff in the same spot in the vehicle. And I don't know, there's a little bit of instruction for first responders. Even if I didn't have this, I would still function through it as I would now as a peace officer pulling over somebody. But it's just something that we thought was valuable. And so we went with it. It's pretty simple, I guess. We funded it ourselves and move forward.
Co-Chairman Washit.
Thank you, Mr. Chairman. Sheriff, glad you're here today. So you heard some of the potential complications that may come if the state of Wyoming takes over this program. Correct. Might go off in a slightly different direction. Yeah, I'm
more
not complicated.
Correct.
Would you prefer to run your own program or to, because my guess is if we go to a statewide program, it will preempt local.
Yeah, that's
programs.
something I'm not looking for. I mean, it's voluntary that we did it. I don't want to have another rule that we have to follow by the state saying that we must do it. I think that there might be a different avenue if the state came up with something from possibly the patrol or to be put out at where the driver's licenses are distributed, you know, that they had their own envelope out there. I don't think it matters if I see blue envelope, it says state of Wyoming on it or Wyoming Highway Patrol, it's going to matter to me. But I'd rather not have a mandate on it over our office.
Representative Lean.
Thank you, Mr. Chairman. Thank you for joining us today, Sheriff. My question is, when you talk about the cost, how much did this cost your?
I think we did 500 envelopes for $200.
Thank you.
Representative Filer.
Thanks, Mr. Chairman. Sheriff Becker, this might be a couple questions, but I'm pretty sure your deputies and actually every law enforcement agency in the state are probably well-trained in operational security awareness around your environment, those types of things. Is that correct?
Yes, sir.
Follow up, Mr. Chairman. So with that, when you walk up, say you're just doing a regular traffic stop and you walk up to a vehicle and it has the mom and dad and 3 little kids on the sticker, all that kind of stuff. So would that change the way you approach that vehicle, that sticker?
Not necessarily.
Okay. Mr. Chairman, also, what if you was to go up to a vehicle that had something of government stay out of my life and a bunch of guns and all this other stuff on the back window of the pickup? Are you going to approach that vehicle in a different way?
You're gonna have a different attitude when you approach that vehicle, but you're gonna approach it the same way. And you know, I might approach it from the passenger side, something different, that nature. I maybe ask for somebody to head that way, maybe not, because we usually work by ourselves anyway, so you just handle it. Yes, sir.
So I think what I'm getting at is more of, I think every time, you know, you go through a traffic stop, you guys are all trained at, you know your situation, you know you'd look at all the different clues before you put yourself in a dangerous position or or anything like that. So this decal, like to say the state, we decide to do this decal. Would you approach that vehicle different once you know what that decal is?
I don't, I'm not gonna do the decal. We're not gonna do the decal. You know, I look at everything on the vehicle when I walk up, but I pay attention to what they say, but I'm more focused on the person driving and the people within the vehicle. You know, even if they have a Wyoming Highway Patrol decal on there, I'm gonna say, you know what? If I was a bad guy, I'd have 10 of them on my car. So.
Now, wait a minute. What if they have a state legislature?
Oh, I could tell you a couple stories about a couple of those folk years and years ago.
Representative Filer?
Yeah, and thanks, Mr. Chairman. And I think Sheriff Becker, one thing about it, if we do a statewide one, it's gonna be a voluntary program. So
Correct.
it's actually the people that want to use it are the ones that are gonna have to ask for it to get it, right? It wouldn't have to be the sheriff's department asking for this. It's gonna be the participants that actually ask for it.
Correct.
That's the voluntary side of it. So a lot of times it might come with this decal. And I think the one thing I'm thinking about is as your surroundings and you approach that vehicle with that decal, it might make you think, okay, there might be a person that is sensitive to certain different things, and I'm going to approach this a little bit differently than I would, the van with "I hate government, cops stink," bunch of guns all over it, whatever it might be, right? You're going to approach that vehicle a little bit different, but I don't think anywhere in this, if we do run a bill, it's going to make you have to have people put decals on their car, right? So with that, also, I was thinking, there was a question asked earlier about human trafficking. And would this decal or this envelope increase human trafficking, or would something more on the lines of the mom and a bunch of little kids and the dog, would that also be about the same for human trafficking over this? What I'm trying to say is what I'm trying to find out is, do we see a real problem with human trafficking at all with this envelope?
Not in my opinion. Just, when you're looking at the other decals too, I don't, not in my opinion.
Okay.
That I feel.
That's all I have for now, Mr. Chairman.
That was a true cross-examination. I just let you go. Senator Kolb.
Well, thank you, Mr. Chairman. There'll be no more cross-examination. Sheriff, my concern is making a job harder than it already is. Because it's getting harder every day for you, Highway Patrol, everybody. So far, this program, you're amenable towards the way you're deploying it. I would like to hear if you hear anything that would make your job more difficult. That's my concern. Thank you, Mr. Chairman.
You'd like to hear anything I've got? Yeah, I don't look anything. I think the thing that sticks out in my mind with this envelope that would, if we deal with a lot of diabetic people that have called in as ready reports, it seems like that's more and more prevalent. Got a red report, they're kind of driving over the road or whatever, pull them over. If they handed us one of these and it was marked diabetic, that might give us a little bit of a insight to why they're passed out behind the wheel, or if they have, if we get one of these. Now, are we going to believe what it says? I think we're going to do our investigation and determine whether the person is diabetic, or he got one of these and he thought, well, I'll put diabetic on there because maybe I'll get out of a DUI on it or something. So, I think that way all the time, right? Anything we do, we have to really think through it. But that might, we deal with a lot of autistic people and like Deputy Cuomo said, doesn't mean they're so autistic that they can't function. They got functional autism. Limited vision might be interesting. Some of the stuff is diabetics. some people have the seizures disorders. I think this would be just as good for the first responders in a crash if it was located in the vehicle, if it wasn't handed to us, because obviously if there's a crash, you need to be handed this. But a lot of times there's a crash, we might look in the glove box for registration or something if we can, or it might be scattered. I don't know. I don't see any downsides to it as long as you're thinking when you're receiving this. This isn't a go free card. It's just something that's giving us a little information on the person. And it might make the person in the vehicle feel better that I know if I had all my stuff in one envelope, when an officer pulled me over and I just handed it to him, it'd be much easier than trying to look for it, because I had to do that the other day. So, yeah. So I don't know if that answers your question or not. I didn't see any, when I looked at this, I look at this as how it can be used, how possibly if I was a criminal, how I would use this against peace officers. I do that with a lot of things, and I didn't see anything that concerned me other than somebody using it to check the box to try and get out of something. But that's in my mind. And the undersheriff felt that it was a really good program. He's been around a long, long time. My deputies felt it was a good program. And, we're, like was mentioned by Mrs. Campbell, Representative Campbell, we're dealing with a lot of these people with medical issues and mental issues more and more, it seems like. So kind of was something that we just decided to implement.
Thank you, Sheriff. Let's hear from Highway Patrol.
Good afternoon, Mr. Chairman. Carl Germain, Lieutenant Colonel, Wyoming Highway Patrol. I got a few things to add on this topic. Probably about a year and a half ago, I was asked by then Colonel Cameron to look into the Blue Envelope program. I didn't know that much about it. Quickly found out that one of the bigger agencies in the country that oversees a Blue Envelope program is the San Diego County Sheriff's Office. So I called down there, spoke to the person in charge of the program, was nice enough to walk me through what it was, sent me out a bunch of resource and material, and also realized that from a highway patrol perspective, to implement something statewide would take most likely some kind of legislative action, just given a cost, albeit it's not a great cost, but the logistics of purchasing envelopes and stocking them. The deputy that I spoke with didn't say anything necessarily in regards to officer safety issues. We do teach traffic stops the same way as all law enforcement in Wyoming, to take a traffic stop very serious, always focus on officer safety. You have a lot going on. It's a dynamic situation. You have multiple people in the vehicle, could be daytime, nighttime, weather events, interstate, busy city streets, busy county roads. No single traffic stop is alike. They're all different. You get all walks of life. You get to meet interesting people, but fortunately you do come across some very, very dangerous individuals. Officers in Wyoming are trained to recognize criminal interdiction. We do that at the Highway Patrol. We teach it in the academy. We spend a lot of effort or focus a lot of effort to send our troopers to advanced training, whether it's desert snow or something else that focuses on human trafficking, drug trafficking, weapon trafficking. It's all the same. A lot of times what you see with people involved in any kind of a smuggling is deception. They're always trying to throw you off and say, look at me, I'm a good guy, I'm not doing anything wrong here. And that's why you can't let your guard down on a traffic stop. So should there be a sticker implemented, it's a cue. It's a cue for an officer to recognize that there could be mentally handicapped person inside the vehicle. The blue envelope program, if you walk up to a vehicle and someone hands you that, it's not an automatic get out of jail free card. It doesn't mean that you let your guard down. It just is a visible cue to that officer that recognizes that you have the potential for an autistic person or someone with another mental handicap present. We at the Highway Patrol train all of our troopers in ICAT, very similar to a CIT where we focus on de-escalation. There's definitely been a rise in or across this country of people with mental handicap having violent encounters with law enforcement. Those encounters oftentimes lead the officer to using a deadly force. It is justified a lot of times, but I think what the training is designed to do is to teach officers how to recognize the signs, communicate with people, slow things down, de-escalate instead of escalating. And so if there was a means for the Highway Patrol to assist in any way, I'd be happy to help. I view this as a program that spreads awareness and maybe saves lives. The other thing that we do internally is there's a lot of different kinds of disabilities out there. One of the ones is hearing impaired people. We have some control over how we can interact with those people. So we provide just a basic card for troopers that has symbols and words such as driver's license, you're being cited, you're being warned, you're under arrest, do you need help, do you have a medical emergency? The fact is that we're going to continue to encounter people during traffic stops that have disabilities, and our main focus is preservation of life and helping, and I view this as a way to make it easier and less traumatic for those people during a traffic stop, which is already a traumatic enough for someone with a mental handicap. And with that said, Mr. Chairman, I'll stand for questions.
All right, thank you. Was it Jermaine?
Yes.
Thank you. Mr. Thompson.
Thank you, Mr. Chairman. Alan Thompson, Executive Director of WASCOP. I have the unique position out of the law enforcement that you've heard from today to represent 80-some members across the state. We've already heard 4 different ideas on how we can implement this. And I would just maybe suggest that the committee consider some sort of voluntary program, hopefully funded by the state. And $200 for 500 envelopes is pretty cheap for.
You want it voluntary and you want it funded by the state.
Right.
I think that's having your cake and eating it too.
Yeah, well, yes, it is, Mr. Chairman. But I'll say that because we have one-man agencies across the state that might be expected by the constituents that they serve to have this envelope. And what's the printing cost for them to print 5 envelopes that they'll use over 10 years, as opposed to bulk buying power and sharing of the resources across the state. So if YDOT and Highway Patrol were able to do that on the state level, look at all of the things that we already do with DUI paperwork. It's standardized, it's issued by the state. The locals get those hard forms from the state of Wyoming and use tickets. I mean, it's all a standardized process across the state. And, that small sheriff's office that has 3 members just doesn't have the manpower to take this on, but knows to direct them to local Highway Patrol or the local police department. So it gives that ability for agencies to, what is also, I mean, we haven't talked about this today. This is a great community building, bridge building process to put that out to the public and have those encounters and help those people that might be struggling in a traffic stop, maybe experience what it looks like to have these flashing lights and meet and talk to someone in a uniform and see that they're not what their preconceived motion is, or their preconceived idea of it is. I know this has been said before, but I will say that some will game this system, but also some who legitimately qualify for this can be a danger to officers. And that's where it just comes down to the individual officer treating each incident separately. We could what if this to the end of the day. I think it's a great program that both state and local can work together on, as long as we keep it simple and inclusive and not tie in specific colors, specific titles, if we can make this as general as possible. I'm just thinking about, we talked about CIT today and I heard the acronym for the first time today, CCAT, ICAT. I don't even know what that one is, but they all are de-escalation training programs that work for those individual agencies. So if we can be as general as possible and inclusive, I think this will work for all law enforcement across the state.
Yeah, Mr. Thompson, in terms of it being voluntary and funded by the state, the way that, at least in all the discussion that we've had today, the one that surfaces for me as making sense in meeting those two categories would be simply YDOT producing the envelope and the envelope being at driver services. And then it doesn't fall into the hands of law enforcement to distribute the envelope at any level. It's just when you go and you get your driver's license, you see the stack of envelopes there. Oh, that's me. And then you get an envelope. I don't know what your thoughts are on that.
Yes, Mr. Chairman, as long as the language of any statute related to that or rules by YDOT doesn't prohibit local law enforcement from maybe getting their hands on some of those envelopes and also doing this program. So as long as it's not limiting, yes, I think that's a great idea, Mr. Chairman.
Okay, great. Co-Chairman Washit.
Yeah, thank you, Mr. Chairman. So, Mr. Thompson, I guess I'm a little torn here because it seems almost obvious that if the state takes this over and produces envelopes, there's going to be rules about process and procedures of who gets them, who doesn't get them, how do you get them, yada, yada, yada. Seems to me for the cost, we're not talking about buying robots for bomb squads. We're talking about envelopes, right? Can't agencies find $200? I don't know how many autistic people we have in Wyoming who might qualify for this program. And it might cost more manpower wise to produce a new state statute to put this program together than it would cost the sheriff to print up a few dozen envelopes and hand them out to the small communities that they serve that can't afford them out of their own budget. So I just wondered, if there was a real need to have a standardized envelope that everybody had, I could kind of see the state taking this thing over, but I am wrestling with the price tag's not that great and the value of local control seems to be significant here, whether you want stickers, you don't want stickers, how do you hand them out, who gets them, who doesn't get them? I don't know. Do you have a preference?
Yeah, Mr. Chairman, thank you, sir. I just say that because if there's a statute that is involved with this, what you guys talk about today and what we see next July 1st may look drastically different. So I'm just standing up for any unfunded mandates that we've seen in the past. And I agree with you 100% that this is affordable on the local level and something that I don't think will stray too far, because when the next county down the road decides they want to do this program, they're going to call up Converse County and say, hey, send me one of your envelopes so I can copy it. They're not going to reinvent the wheel. So yes, Mr. Chairman.
Representative Bratton.
Thank you, Mr. Chairman. Thank you, Mr. Thompson, for being here today. So I know in my county, the awareness is great of this, and the support for the autistic community. But there also have been concerns raised by my local law enforcement that you said that every county is different. Some of them have already implemented a similar program. Maybe not a blue envelope. But one thing I have heard loud and clear is that although they're definitely encouraging awareness, but they do not want a state mandated thing. And particularly they're concerned about additional training. And I heard on the one hand, the bringer say, no, we're not talking about additional training. But then I heard some other law enforcement say, yeah, there might be some training required with this. And I know I heard some definite concerns from my local law enforcement on being told how much and what type of things needed to be in the CIT type training. So I just I wanted to raise a concern and Mr. Thompson, just to ask if you, as you speak with the groups that you represent, that you will go and ask them some of those same questions.
Mr. Thompson.
Yes, Mr. Chairman, I would gather that information. I do know that, you know, just restate that specific language, specific programs in statute is what makes it difficult for law enforcement. The reality is that de-escalation training of some sort is part of the academy training, it's part of FTO training, and it's part of ongoing training within agencies across the state.
Senator Cole.
Yeah, thank you, Mr. Chairman. Well, Mr. Thompson, I have a question for you, maybe not an answer right now, but just a question to bring back to your folks and ask them. My concern is, the general question would be, is would you be in favor of an exemption that would basically not imply any liability upon your law enforcement folks for someone having a blue envelope, any extra liability? I'm concerned that there's going to be a perception that I think in the reality, at the end of the day, you have a blue envelope, you've afforded some other sort of protection or expectation. And for your association, just I think maybe we could talk about drafting an exemption potentially for any liability because of participating with the blue envelope program. That's my general question, Mr. Thompson.
Because immunity isn't enough? We already have immunity.
Well, yeah, I don't know if that is enough.
You want more immunity.
I just don't want to add to the liability.
Okay. Mr. Thompson.
Yeah, Mr. Chairman, I do think that that's actually better answered by the attorneys that defend those cases than our members. There is a concern, I think, from most law enforcement that there's, you know, a risk that attaches to certain things, whether that's actually the facts or not, might be somebody outside of our realm to answer that best.
Representative Campbell.
Thank you.
Bring us home.
Thank you, Mr. Chairman. I think what I would like to speak to is the intent of this program. And it is not a law enforcement program. It is not a law enforcement mandate. It is not a law. It is for the resident. It is for the constituent, right? It is a voluntary program that they can choose to participate in, that then the only mandate for our law enforcement is that they're aware of what the program is, and that it is an indication of the individual they may be having in exchange with. It really is, it comes from the individual, and how do I communicate more effectively with law enforcement? Because I know I have these challenges, and in changing environment and situation, I may not be able to respond in a manner that the intent is as it is perceived. Maybe I am overwhelmed and it comes across as being non-compliant. So what can I do to better ensure I can communicate my needs to law enforcement? That's what this program is. So it makes sense to me that the state adopt it at a statewide level, telling all of our residents, it doesn't matter if you're in Sheridan County, or, you know, if you're in Sheridan or Casper or Gillette or Meeteetse, our law enforcement are aware of the program. You'll be okay. That's all it tells them when we adopt it at a state level. So if we adopt it at a state level, there is no mandate that every sheriff is going to have to buy things or every sheriff is going to have to do training. That's nope. As a statewide adoption, it says to all of our residents, every law enforcement at every level is aware of the program. We know what it is. If you would like to opt into this, go to your driver services. So I would ask that the committee, as you consider this, keep it simple and keep the intent with our residents.
All right, let's take one more question from Representative Webb, then we'll see if there's any other public comment.
Thank you, Mr. Chairman, and I appreciate the conversation. I just did a simple Google search. Does the Blue Envelope program provide envelopes? Yes. The Blue Envelope program provides physical blue envelopes designed to hold a driver's license, registration, and insurance card. There's a solution for each individual entity, law enforcement entity that wants to participate to do this free of charge.
I think that was AI. That sounds like AI. All right. Let's see if we have any general public comment. Yes. Ms. Semino. Thank you, officers and sheriff. You are excused.
Mr. Chairman, members of the committee, Lindsay Semino with the Wyoming Behavioral Health Alliance. I had all kinds of comments that have been answered, so we will get to the only point that wasn't highlighted today. When it comes to whether or not this is a local control or a state implemented program, we do believe that a state implemented program is best because of how our healthcare system is in Wyoming. And that is the only point that hasn't been commented on. We are a regional healthcare system, meaning we know that not all health services are offered in every county and in every city across Wyoming because we're too frontier of a state. We also know that a lot of our Wyoming residents and families travel to specialists that are even outside of this state, whether it is to Denver, Billings, Salt Lake City, et cetera. And therefore, having that state implementation of the program, we think would better serve Wyoming families because then the entire state is on board regardless of what county they are traveling to or from. Our understanding as far as the mandate and implementation is that it is a mandate for the program to be implemented, but definitely not a mandate on law enforcement. Obviously, we want to support our law enforcement in any way possible, and we think this program can be a major tool for them in that endeavor. And with that, I stand for question.
Any questions for Ms. Semino? Yes, Co-Chairman Washit.
Thank you, Mr. Chairman. I didn't catch your last name.
Semino, like the
Semino?
state park, but not.
Okay. So, Ms. Semino, do you have any idea how many people we might be talking about in the state of Wyoming who might want to have a blue envelope in their car? And is there an association in the state that might provide the envelopes instead of creating a state program? You know, that I'm hearing we want our cake and eat it too, as the co-chairman said, right? We want a statewide program with no strings attached, no mandates, no training, just $500 worth of envelopes. And I'm thinking we're going to change state statute for $500 worth of envelopes. So how many do we have? And is there a statewide association that might adopt this and be responsible for helping their local law enforcement understand this program?
Ms. Semino.
Mr. Chairman, Representative Washit, I will not be able to say how many people today. I can absolutely get that number for you and bring it back to the committee if that pleases the committee at a later date. What I can say as far as a group agency or an association, the issue that we're ultimately talking about is infrastructure. And whether there is another agency or association that could take this on is a possibility. Whether or not they have a physical location in every county, though, is a different endeavor. The advantage of having it at the DMV is what has been previously testified to as far as applying for your license, whether you are the caretaker or the person with the diagnosis, seeing those resources available to you and knowing that there is a DMV in every county. The infrastructure is there for the DMV to be that point person, whereas a different agency or association does not have that infrastructure, or I should say is not guaranteed.
All right, thank you. Any other public comment? You know, Mr. Co-Chairman, all of the time and money that goes into creating a blue envelope statute, we could, if we weren't studying Title VI, we would have the time and money to do that. I'm just saying. Brian Fuller would have a little bit of spare time. All right. With that, I will close public comment. Committee, there's a couple of topics that, I'm sorry. I will reopen public comment. bring him in.
Good afternoon, Mr. Chairman, committee. My name is Ryan Semerad. I'm a lawyer in Casper, and I am the father of a autistic child, and heard about this program. Wanted to give you my comments on this, or heard about you guys were going to talk about this. Been paying attention for most of the hearing, so I had lots of thoughts on lots of your other topics. You can email me later. One second, Gia. My daughter is here. I am now doing my dad thing, which is part of being a special needs parent. Is you don't get to just do your job, and you have a lot of other things you have to do, which includes coming home early sometimes. I think that this program is a really good idea. I encourage you all to study it and think carefully about it. As a criminal defense lawyer and a parent of a child with special needs, I think how law enforcement immediately understands or doesn't understand a person's abilities is essential, because communication, verbal communication, is usually the only link between an officer on the roadside and the occupants of a vehicle. And for someone like my son, he's a level 3 autistic person, he has high support needs, he's nonverbal, he likely will not have verbal communication skills. He uses an alternative communication device. It is very unlikely that an officer is going to encounter someone like him. He's not one of the 31 out of 100 or whatever the statistics are who are diagnosed autistic because of the level of his needs. And there are going to be other people in our community who have high level needs like my son. And when they encounter a law enforcement officer, most likely as a passenger, not as a driver, there are times when officers want to ask questions about everyone inside of a vehicle, and having some kind of preemptive program that notifies the officers so they don't have to ask additional questions, especially because you're not going to get a verbal response. I think it's a really smart idea because it protects people like my son who aren't able to really self-advocate in that moment expressively. And it may be interpreted as noncompliance. It may be interpreted in some other way because officers, rightly so, are prioritizing their safety in that moment. I think that something that does this on the front end, hey, we know right away there's an occupant in this vehicle, the driver of the vehicle, if it's a lower support needs person, has these communication differences. They have unique sets of needs and skills, strengths and weaknesses. I think that communicating that up front in a nonverbal fashion that is relatively discreet, whether we talk about putting something on the exterior of the vehicle like a decal, or whether it's just the blue envelope program, I think that's good. I also think the community does need additional education on what services are available. For example, I know in Natrona County, I was able to register my son with the Natrona County Sheriff's Office. He now has a flag in his system if he were to ever have an encounter with law enforcement. This was free, took one phone call. They can flag, hey, if you encounter my son and you pull up his date of birth and name, you will know right away that he is a high-level autistic person, nonverbal. Very quick and easy to do. That's one phone call, at least in Natrona County Sheriff's. I'm not familiar with the other county sheriffs and how they function. But anything that parents, guardians, caretakers can do, like a program like this, that can help facilitate that to maybe lower the temperature on what can be perceived as noncompliance preemptively, I think is smart. Whether it should be a state issue or a specific local issue, I think that's something you guys can hash out, and you have better ideas on that than I do. But I wanted to voice my endorsement and support of the concept and the conversation. And I did want to applaud the Converse County Sheriff's Office for taking this on. That they were the first ones I became aware of who did something like this. I just think this is an excellent idea because it protects the person and law enforcement so that they don't believe they have to start climbing up the escalation ladder because they don't know what they're dealing with, because the person may not be able to tell them. So I just encourage you all to think about this. I don't have the right answers. I don't have all the answers, but I think it's a really smart idea. And I'm very happy that you guys are having this conversation. If there are any questions for me, I'm happy to answer them, but I just wanted to voice my support for this process.
Not seeing any questions, but thank you, Mr. Summered.
Thank you.
All right. With that, I will officially close public comment. Committee, we have 3 topic areas. The DUI topic area, it sounds like there probably is not a need to take any action because we don't have enough information. We'll be receiving some more information about that for our next meeting. But let's start with the first. Go ahead.
I do have a motion relative to the DUI question.
Oh, okay. Well, let's just take them in order, if you don't mind. I was
with DUI.
I know. We didn't start with DUI. We started with vehicular homicide. Oh, I just did. All right, let's take your motion. You convinced me.
So, Mr. Chairman, I appreciate the opportunity. I would move that we ask LSO for a bill draft relative to amending 65204, which is our interference with a peace officer statute, to include a new subsection specific to those people who knowingly and intentionally interfere with the peace officer who's attempting to execute a lawful search warrant for the drawing of blood pursuant to a DUI arrest. And then the committee, just leave the penalty open and the committee can debate what might be the appropriate penalty. The idea being create a new subsection of interference with a penalty sufficient to make it more punitive than giving up your blood would be. And that way we'll get the blood and we'll be able to pursue these cases.
Second. Okay, it's been seconded. Is there any discussion on this bill draft request? Yes, Representative Lean.
Thank you, Mr. Chairman. Just a question. Could you repeat knowingly and?
Intentionally.
Mr. Fuller's got it.
Knowingly.
All right. All those in favor signify by saying aye.
Aye.
Any opposed?
No.
All right. Is there any other requests on the DUI topic? Senator Craig.
Mr. Chairman, I don't know. I mean, the request that Mr. Thompson discussed is pretty simple and straightforward. It's just making those two statutes have the same language. I don't know if that very discrete issue, if we could have a bill draft done at the next meeting, I think Mr. Thompson could work with Mr. Fuller and we could have a draft done on that as well to discuss if we have time at the next meeting, because that one seems pretty simple and straightforward. There might be other issues that we're not aware of today, but that particular one that Mr. Thompson brought up seems like we could do that. So I guess I'd make that motion as well.
Second. Okay, moved and seconded. Any additional discussion? All right, all those in favor signify by saying aye.
Aye.
Any opposed? Any other directives on DUI? For now, that'll be it. Okay, let's talk about vehicular homicide. Are there any committee directives with respect to vehicular homicide? Senator Crago?
Mr. Chairman, I mean, I would like us to bring forward a bill draft for consideration at the next meeting. I think the tricky part, and I don't know how we do this exactly with, I'm sure Mr. Fuller can put something together. I would like us to have us essentially take out the reckless language, replace it, as I talked about earlier, with discrete actions that create the crime of aggravated vehicular homicide. And so I think we could essentially start with some of those that were given to us by some of the folks here testifying today, and then leave it open-ended to either add or take out any of those. You know, for example, as we were looking at the list, the quote unquote legislative ask, you know, I think the first three make total sense. 4 gets a little ambiguous. I don't know how we define that. You know, I was thinking as we were hearing testimony, for example, I mean, if you've had 2 DUIs in the last however many years, does that qualify as dangerous traffic offenses? I think it does, because if you've had 3 in 10 years, then that's a felony in and of itself. And so I think we're going to have to work on that. And I doubt we get that right. You know, if we had a draft we could look at between now and our next meeting, all of us could start looking at that list and either adding or taking out, and ask around with the folks we know, ask our prosecutors, ask our law enforcement folks, hey, what are some things we could add to this list that you've seen over the years that should qualify under this statute, but you haven't been able to prosecute them previously. So I guess I'd just like to start with that so that at least we have something. It might be a rough draft, but at least it would be a draft that we could move forward. So that'd be
So
my
you're,
motion.
so you're asking from Michael Cusick's handout, the legislative asks proposals 1, 2, and 3 as a starting point. And
Yes.
the only other question I have is why not just add those to the statute? Why delete the reckless? And the reason why I ask that is because I really think that was intended to be a catch-all that was supposed to give prosecutors a tool when they needed to fit something in that wasn't on a list. So
Mr. Chairman, I'm not opposed to leaving it in. I just am not sure how often it gets used because of the definition. So if it's there, I'm not sure it hurts anything. I just don't know if it helps anything either. And so I guess it's up, it's up to the committee. It's up to you, Mr. Chairman. I'm not opposed to leaving it in. Maybe we draft in such a way that it could be taken out if we have testimony later that it's not helpful or, makes the issue more complicated. I don't know the answer to that. I've never prosecuted one of these cases. So, but I think we can talk to the folks that have and try to figure that out. That was my only thought, was that I'm not sure it helps or, moves the needle of what we're trying to do. So, but may not hurt anything either.
Okay, is there a second?
Second.
It got plenty of seconds. Mr. Fuller, does the motion make sense to you? I mean, the reason why 1, 2, and 3 are not, that's not the legal language. Obviously, there's going to be a lot of leeway to making that work. I mean, 3 is probably the most obvious, alluding, that one's easy, but I think number 1 is probably the one that needs to be finessed the most.
Yep. So Mr. Chairman, all 4 of these, and for the 4th one, I'll limit it just to the reckless driving, but all 4 do have a connection with another statute in Title 31 that makes these a violation. Obviously, if the committee has different designs for example, number 1, that statute says that you have to be sending a message by text or to a like an instant messaging or an email for it to be a violation under that statute. Mr. Chairman, that could be a starting point. I can draft it really any way the committee wishes. If it wants it broader to say, you're using your phone, and while driving and that causes death. I think there's a wide variety of possibilities for the committee, to proceed with this bill draft.
Senator Craigo.
Mr. Chairman, I'm a little bit leery about expanding that particular one. I think we will run into issues by expanding that in particular, simply because we will essentially be creating a new crime that doesn't already exist. On multiple levels. So we're going to be creating a different although it's not prosecutable in and of itself, I think it creates a different issue. I just as soon tie it to existing statute as they exist now, because then it's much easier for our prosecutors to prove the case.
And that is specific to texting while driving, or is there a statute that specifically uses the language distracted driving?
Mr. Chairman, I'd have to pull that up. But I do know the elements of that, and I'm not sure how that statute's entitled. I think it's 31.5.237. But what I do know is that for the elements, for that offense, for a person to be convicted, it has to be, basically sending a message for it to be a conviction under that section.
All right. Additional discussion?
Mr. Chairman.
Yes, Representative.
Thank you. I just have a comment on the term reckless and taking it out and then listing things. But my understanding is legally, if we start listing a lot of things, then we have to be careful that if something is excluded and the judge wanted to bring it back in, they can't, because if you start listing a lot of things, then there's an exception. So I would concur, I think, in leaving it in for now. As a catch-all.
Senator Craigo said he's okay with that. Yeah, I agree. I say we leave it in the draft, the current subpoint for reckless manner, and then we can always debate it more and decide what to do with it. And actually, maybe you could look at the legislative history on that, because I am just curious what we can find as to the creation of that statute. What were they thinking when they put it in? All right. All those in favor signify by saying aye.
Aye.
Any opposed, no. That amendment has been adopted. Are there any other directives? Yes, Co-Chairman Washit.
Thank you, Mr. Chairman. Just see what the temperature is of the committee to looking at that texting and driving law that Lieutenant Colonel Jermaine brought up. The problems with that being largely unenforceable because of the elements that are contained within the existing statute. That, should we take that up, take a look at that statute and look at amending it in a way that deals with handling or operating a device while you're driving without requiring the evidence of texting as he described? Apparently the temperature is low.
You wanted to know the temperature. All right. Any other directives on vehicular homicide? All right, that's it for that topic. Last topic is the Blue Envelope Program. Are there any directives on the Blue Envelope Program? Representative Filer.
Thank you,
We'll
Mr.
save, I know you want to make a motion about sunshine and rainbow bill, but,
Unicorns.
and unicorns, but we'll go to Representative Filer first.
Thanks, Mr. Chairman. I don't want to talk about rainbows and unicorns and all that, but I would like LSO to write the most simple piece of legislation ever. No mandate, that YDOT handles the Blue Envelope program and a small campaign to get it out to the communities to let people know how the process works with that, with working with the Blue Envelope program online. But I think that this is well worth, researching and getting into. And I think a small piece of legislation that just says it's gonna be handled by YDOT. Any law enforcement agency, anything like that can get more envelopes from YDOT. And that we also get a fiscal note on a possibility of how much it'll cost YDOT to administer the program. But I want to make sure that it's also written in a way that it is not a mandate to any county law enforcement agency. Anything, Department of Health, take every single department you could think of. It is not a mandate. This is a voluntary program by the citizens of Wyoming if they want to participate in this program. All this does is allow them to want to be able to participate in that program. They voluntarily do it. And that YDOT administers the envelopes and puts out maybe a little 2-minute video to every single law enforcement agency on what it is. That's it. Just as simple as we can get it.
And this is non-codified.
Yes, sir.
Is there a second? Seconded? All right. You want to discuss this motion or you want to wait for your, you have a separate motion?
Another motion.
Of course, about rainbows and sunshine. I just add to discuss the motion. In so much as I think I would like to just clarify, the intent is to have a uniform Blue Envelope program throughout the state of Wyoming. In other words, it'd be a uniform, whatever it would end up being, that we would all use the same one. I don't know if that was the intent of the draft.
It is.
Okay, well, sounds fine. Rainbows ahead.
All right. Well, Senator Kolb's on board, so I don't know how that makes the House feel. The House looks tired.
Temperature's low.
Temperature's low on that side. All right. Any other discussion? All right. All those in favor signify by saying aye. All those opposed? Oh, we almost made it the entire day, folks. We almost made it. All right. All those in favor signify by raising your hand. 1, 2, 3, 4, 5. All those opposed? 1, 2. Wait. 1, 2, 3, 4, 5, 6. Bratton, 7. And Senator Crum can't even hear us. All right. Well, that motion does fail. Senator Kolb, did you have something else or you?
Oh, well, Mr. Chairman, I'd try to make a motion that we have a bill draft that simply had a uniform, printed envelope issued for the blue envelope program available to a county that would wish to distribute them. That simple.
Okay. Feel like that's what did you vote for the last one?
I did not. I did not.
That was exactly what. the
No, it
last
wasn't. It
motion was.
included minimal money. Mine has no money.
Oh, the county has to print the envelope themselves?
Oh, most certainly.
Oh,
But we'd offer a uniform envelope, so we would have one type of envelope throughout the state of Wyoming. There wouldn't be any confusion with the local law enforcement folks.
okay. That one's been seconded and that's non-codified as well.
Yes.
All right, just making sure. We don't want to spend the money to print it in the green book if we don't have to. Trying to be fiscally conservative here. All right. Any other discussion? All right, all those in favor of this motion signify by saying aye.
Aye.
All those opposed?
No.
All right, I don't think we're getting anywhere. Any other directives on the blue envelope program? No? Okay, then here's what we're gonna do. We have 2 topics left. We're gonna take a 10-minute break. The Wyoming probate code is only gonna take, it says 45 minutes, but it's only gonna take like 5 to 10 minutes. It's just an update for you guys. So that one's gonna go really quickly. And then we'll see how we can tackle guardianship task force discussion. So let's take a 10-minute break. So the guardianship is just supposed to be the establishment of the task force, but Stivar brought in a whole bunch of people. All right. Are we live? Okay, we are back. Couple of topics to finish up for the day. The next is the Wyoming. Oh, I just noticed we're past 4:15. It's recess on the agenda. No? Okay. All right. We're Wyoming Probate Code. We do have Mr. Meyer to give us an update from the estate planning, elder law, trust, and probate section of attorneys who have been, just committee, so you're aware of what's going on. There's a subcommittee that's been meeting with attorneys who practice in this area. And you're going to hear from Mr. Meyer about this in a moment, but they've developed a pretty substantial document and they continue to work through it. And the idea is at some point when they're ready, they'll bring that forward to the committee. But today we're just going to hear a brief update on where that subcommittee is at. Mr. Meyer, welcome.
Thank you, Mr. Chairman. Can you hear me?
We sure can.
Good. Yeah, Scott Meyer on behalf of the State Bar's Estate Planning Group. Myself and Lance Harmon are the co-chairmans of this prestigious group of attorneys and judges and trust officers who are trying to update the Wyoming Probate Code. We've been having monthly meetings. Now, definitely through this year, we kind of started towards the end of last year, but through this year, those meetings have started with kind of going through the probate code and maybe picking more of maybe the less cumbersome sections of the probate code. But now we're working into the more difficult areas. The meetings have really been gone through talking about what works and what doesn't work, and maybe what we have problems with. And we've been very blessed to have a couple of judges on this committee as well, who have been not so much on the drafting part of it, but telling us what they think will work and what won't work. And right now, Mr. Chairman, we are to the point, I think, starting this coming Friday, which is our May meeting, to start putting pen to paper so that we can actually present something to you folks so that we can and maybe work with LSO sometime this summer. I kind of wonder how this thing is going to work over the next month or two, because it seems we have a lot of people going on vacation and school gets out and what have you. So we'll see how that plays out there. But that's our objective, is sometime this summer to at least have something written with all the changes, kind of a red line strikeout with the Wyoming Probate Code, and then to have this group look at it and be able to answer questions. And we'll have as many of those people available for the committee to look at. So that's where we are. I think we're moving forward, Mr. Chairman, but it's always kind of a slow process because people bring up things that I had not thought of and issues that come up. And then, of course, our judiciary brings up things that they think has always been problematic as well. So been a little bit longer, slower than I'd like, but we are making progress. And I'd certainly stand for any questions from the committee.
Co-Chairman Washit.
Thank you, Mr. Chairman. Mr. Meyer, are you finding the need for changes or the issues that are being raised in your working group? Are they in one section or one piece of the probate code, or are they scattered throughout the probate code?
Mr. Chairman, Mr. Co-Chairman, I would tell you that they're scattered throughout the entire probate code. I think that we as attorneys and we lobby and try to get changes through the legislature on different areas of the probate code. And we don't do a very good job of tying different things together to make sure that maybe a probate in Wyoming or an ancillary probate have the same kind of language, which often they don't. And so we're finding that there's inconsistencies throughout the entire probate code.
All right, Mr. Meyer, and then in terms of timing, our next meeting is August 10th and 11th. So what I would say is that if this subcommittee wants us to take action this legislative session, I think we would need a written proposal at the August 10th meeting where we would have something, it doesn't have to be in bill draft form, but where we can review the changes that are being requested and have the bill draft put together so that it can be considered at our final meeting. I know you mentioned this summer. How do you feel about that timeline? Do you think that's reasonable that you would have something, and maybe it won't be, I'm sure you could with a subcommittee of lawyers, you could find changes in perpetuity, but at some point you got to kind of call it and say, okay, let's move forward with it. What are your thoughts on August 10th?
I think that's a laudable, a goal right there. I know that, when this first came up, we talked about maybe liking to have something that we could be in front of the general, session in 27. Hopefully didn't have to wait clear till 28, but you're right, that would make sure we have something, in August of this year. So, I think it's a great goal to have, and I think that we'll work very hard to do that. I also look at this and I think you're right. We don't need to make sure that everything is perfect. You know, we did a pretty good job with the uniform, trust code. And as you have seen, we probably have changes in the trust code probably almost annually. Little things that come up, here's things that we didn't think of. And I can see that continuing on, but at least I think that the body of work we want to give you is something that says this is a lot better than it was. There's probably going to be areas that we need to touch on, to make better as time goes on, but I think that, a draft of something like that would be available in August for your meeting.
Great. Anything else, committee? All right. Thank you for the update, Mr. Meyer. We really appreciate that. We appreciate all of the time that you've put into this. And if you could pass along to the subgroup how appreciative we are of all the work that's being put into this. It definitely is a big task, and I know a lot of hours have gone into it. So we just really appreciate everyone who's been involved.
Thank you, Mr. Chairman. Will do.
All right. Committee, with that, we will move to our last topic of the day, guardianship task force discussion. And I want to give a little roadmap on this topic as it is the end of the day. So this was a topic that was added to our committee by Management Council. It wasn't an original topic that you voted on and was put forward. So, but in the discussion with Management Council, what we agreed to do is to set up, just like we just heard from the Probate Commission, this is supposed to operate the exact same way. The goal is for us to establish a subgroup that may contain members from this committee, will contain members from the public and the bar, people who are involved with our guardianship statutes, and they will begin to work. The subgroup will work on the matter and bring something to the committee. It might not be this summer, it might be next summer. It just depends on how deep they go and what they decide. So this topic, we only have 15 minutes for today. So for the members of the public, I know there are many of you who showed up and we received some substantial material, some really helpful letters with a lot of information. But the goal of today is not to take any and all possible testimony on guardianships. Just the purpose of today is just to establish the task force. And at our next meeting in Casper, we will have robust testimony from the public. So just bear that in mind. I'm sorry if you came here today with the thought of what it might look like, but that's what it looks like today. We have asked committee, Miss Lance, if she would be interested in spearheading this subgroup. And then we've asked Representative Stivar if he will also help spearhead this committee, since he brought the topic to Management Council. So that's where we're at right now. We're going to hear from them, and then we'll talk about the establishment of it's not really a task force as so much it is just a subgroup, but we'll talk about that next. So with that, Representative Stivar.
Thank you, Mr. Chairman. Committee Representative Stivar, House District 12. This is on the guardianship. I had a report done by LSO Clayton Caldwell this last year in June about guardianships. The guardianship statutes haven't been touched in 30 years. We used to have an Office of Public Guardianship that fell under the AG's office. 98, that sunsetted, and there was a lot of protections that went away. We really have had nobody look over what's going on within the guardianships itself, how they're run. One of the reports that you have up there is a document that looked at New Mexico, Nevada, Pennsylvania, Minnesota, and Colorado on how their guardianships work. We have no protections for these people. We actually need to do a deep dive. I ran House Bill 101 last year. It went to the Revenue Committee, was tabled. My biggest fear is somebody just like myself running a bill in trying to tweak this statute is the unintended consequences it could have on myself as a guardian or somebody else as a guardian. It really needs to have a deep dive and looked at. So.
Any questions for Representative Stivar? We appreciate you. We really appreciate you bringing more work to us. Thank you, Representative Stivar.
You can thank Senator Nethercutt for
Okay.
that.
We'll definitely thank her for that. Miss Lance?
Mr. Chairman, Beth Lance, attorney at Lance and Hall here in Cheyenne, and family law attorney. So I practice in this area of guardianships quite frequently in my private practice. I would certainly be happy to be part of any subcommittee or task force that would be looking into guardianship statutes and any updates or new provisions that could be added to benefit the best interest of our vulnerable adults under these statutes. I do want to be clear, it is my understanding we are narrowing this just to vulnerable adults and that we are not intending to look into the guardianship statutes as they relate to minor children. So I just want to make that clarification. That has been my understanding from Representative Stivar, but I would ask this committee to also further clarify that. Part of what I think will be important then is ensuring and from the legislation that was presented at the last session that I think some of the concerns raised had to do with the fact that they were, the changes proposed were unintentionally affecting minors and in a way that I think was not intended. It was intended to just focus on vulnerable adults. So that's part of what I would want to be sure that we're doing, that we're focused on the group here that is meant to be focused on, and we're not causing or creating any unintended consequences on other types of guardianships that may exist. Certainly too, then I would be happy to hear what other members this committee would want to appoint, but I would certainly be requesting potentially someone from the Department of Family Services because we are talking about vulnerable adults, and we do have adult protective services and social workers with the Department of Family Services that do specialize in that. And so I think that's potentially going to have a lot of crossover with what may be proposed for changes when looking at maybe additional enforcements or things of that nature on guardians that are appointed for adults in this state.
Representative Stivar, does the scope of that sound like what you were trying to get at?
Yes, this is vulnerable adults, and that's part of the problem is on that draft bill, it took, where I was looking in Title III, that it also was Title 14. Yeah, Title 14.
One of those titles.
Yeah, one of them titles that dealt with juveniles. And it crossed over. That's what I'm saying is we need to strictly do vulnerable adults on this. So I agree with that.
Okay, Co-Chairman Washit.
Thank you, Mr. Chairman. I suspect, don't have the expertise, but I suspect that our juvenile statutes are equally in need of consideration. And my only concern is that because the existing statutes have had some crossover between Title III and Title 14, that if we go to fix Title III, do we leave in place some difficult things within the juvenile code? So at some point, we're probably going to need to have a parallel task force to look at the juvenile side of this.
I would agree with that. One of the problems with our guardianship laws is there's not really like a, this is specifically only minors, and this is specifically everybody else. They blend together. So that is a concern that I have. One that maybe we can try to address to some extent through this subgroup, because it has been a concern of mine for many years. Not heavily practicing in this area, but having practiced in this area enough to at least find some of the statutes to be unnecessarily complicated when they should be separated. Representative Chestick, did you have something? Okay. And so Ms. Lance, someone from DFS. I'm thinking also that we would, is Emily Smith here? Ms. Smith, I received an email from you with a lot of input, and I'm curious if you would like to serve on this subgroup. Sure. Okay, there is no pay, there is no honor, there's a lot of work. But it's all good work, so thank you. Yep, I think you would be a good, okay. I think you would be a good fit. And then from DFS, do we have an idea of, you're here, but are you the proposal, or do you have an idea of somebody from your department? Or both of you? Okay. Okay. I think appreciate that. Very good. Representative Stivar?
And I'd like, for somebody in the public, Miss Miller, Stacy Miller back here, is to be also on the committee. She's done a lot of research, and that's the letter you've got.
Yes. All right.
And she was willing to do it.
Ms. Miller, we have your letter. Unfortunately, I haven't had any time to really digest it yet, but I would welcome a member of the public on the subgroup as well. I think that's fine. Any other thoughts to this committee?
Mr. Chairman, I just wasn't sure about whether either Ms. Butler from the Supreme Court or potentially a district court judge would be helpful. So I would defer to the committee on that, but potentially someone in that realm of the judiciary would be helpful.
Yes, in the probate subgroup, one of the things we found most helpful is the presence of the judiciary on the subgroup. So I think Ms. Butler is nodding along. That's a good idea. You'll find us somebody that is willing to serve. That would be great. Okay. Anyone else want to be voluntold to the subgroup? Are there any members of? Yeah, yes, ma'am, come forward. And you are, introduce yourself to the mic, please.
My name is Faith McCurry. I am a LCSW and have been working with the DD population since '99 and 7 years here in Wyoming.
Excellent. All right, and you have time to commit to this group. That sounds like if you're willing to do it, we're willing to have you.
Yes.
And ma'am?
I'm Kimberly Elfring. I own Cheyenne Habilitation Therapeutics Center. I work with people with different abilities, and I have expertise in all of this because I've been all of this before. I've been a guardian, I've been a case manager, I've been a provider, and a representative payee, and I think I could give insight on that.
Perfect. All right. Are there any members of, sir, were you trying to be recognized?
Yeah. Thank you, Mr. Chairman. My name is Andrew Lemke. I'm an attorney, but I'm also CEO of Wyoming Protection and Advocacy, a legal nonprofit. And our purposes are to investigate abuse and neglect of people with disability. And we also provide free legal services to those with disabilities that qualify. And I've been working in guardianship realm for several years, but I was also heavily involved. There was a task force on guardianship created in 2017 that I was part of. I was the only attorney on it, so I ended up we were trying to propose a whole new guardianship code for the state of Wyoming, and I put that together. And it made to LSO to put together, but then COVID happened and we lost all traction. But I'd be happy and honored to be part of this subgroup.
All right, you are so deputized. I don't really have that authority, but you're on the subgroup. Committee, are there any members from the House or the Senate that would like to be a part of this subgroup? Oh, all right. I think you're probably gonna have Zoom meetings, and you're gonna have the frequency of them will probably be pretty high because of the time between now and they'd have to do all of the work between now and August. I don't know, Ms. Lance, what do you think?
Mr. Chairman, I would agree. We'll have to see, I think, how heavy a lift we think this is and whether we will even be able to present anything as soon as August.
Yeah.
But certainly, I think once the group meets and begins meeting, we will have a better sense of that.
Yeah, and it could develop like the probate section ended up spanning multiple interns. So this could easily end up doing the same thing. You're not doing anything this summer, are you? Okay. You're not campaigning or anything this summer? No. Okay. All right. That's why all the House members said no. They're all up for re-election. They're busy. Representative Filer's in. He's on. All right. We have a representative. Very good. And we'll assign Senator Hicks from the Senate to the
I'll second that.
to the subgroup. All right. Okay. Any other thoughts? And I think, I don't know, Ms. Lance, originally I thought what you might do is reach out to like the family bar section and see, you know, if there are other lawyers that want to jump in. Obviously, the more that practice in the area, the better. And
Absolutely, Mr. Chairman. And I am a member of that subcommittee, and I already had an attorney, Ms. Abby Fournier out of Laramie, who does a lot of guardianship work. And so she already volunteered.
perfect. That sounds great. All right. So staff, this isn't necessarily something that you typically staff. I think the subgroup will meet on its own, and there won't be really much directive from staff other than you've been taking notes on who we're assigning to this committee. So if we can help get that information to Ms. Lance, and then she can, and Representative Stivar, and then they can get the group together. Mr. Fuller? Okay. All right. Very good. Is there any other questions for any of the subcommittee? Yes, Chairman, Co-Chairman Washit.
Thank you, Mr. Chairman. Ms. Lance, sometimes committees can be too large, like nice to get lots of help, right? But I wonder, do you have a sense, is this the right size of a committee? Have we put too many people on this group for you? Just your feedback.
Mr. Chairman, Mr. Co-Chairman, I don't know for sure what Representative Stivar would intend, but I think often if the group is this large, I think I would just be scheduling. I wouldn't necessarily be making sure first that each and every individual could necessarily be there. I think if Representative Stivar and myself can be there, we will schedule a meeting and hopefully get as many participants as possible. I think if we do it that way and we have a larger group, then hopefully we will have significant enough participation at each meeting to be fruitful.
Gee, we put the right person in charge of this. She knows what to do. All right. Very good. I think that's all we have. Thank you.
Thank you.
Thank you.
Is there any other public comment on just on the committee itself? All right. Very good. All right, committee. Well, that ends the work that we have scheduled for the day. We'll see you back tomorrow at 8:30 a.m. Thank you. Anything, Mr. Fuller, that is pressing? Nope. Okay. All right. We are adjourned.